I don't to mention my lord.
Page mentioning. For page mentioning, page number 1, item number 1 and 2. Page number 5, item 3 and 4.
May I please, your lordships? This is the partheard matter which your lordships had heard me on 24th of July, and your lordships have heard Mr. Parija on the 4th. We were wondering if your lordship at any time 11:30, 12 could take it up.
This is on list. This is on list, I think.
Yes, my lord. Item 3.
All right. Just wait. It will reach by 11:30 also.
So deeply laid.
Page 6, item 5 to 7.
Item 5, my lord. Partheard matter also last occasion specifically fixed to 12 p.m.
Everything also.
Item 5, last occasion specifically fixed to 12, taken about 12 p.m. For noting, it is not mentioned, madam. I pray. Yes, I have already said.
Not on record. Next week, I will give the application.
Have you received the
Already received, madam.
list on 25th? It will come on 25th because the affidavit is not on the.
Up to it, 12, madam. It will take only very small time.
Page 8, item 8.
So item 8, this batch of 2J matters, your lordship have already heard petitioners. My friend Mr. Bisraj also argued, and only I think some concluding remark is only, submission is only the left, lords. So I hardly he will take a few time. If your lordship, we don't have any reason also.
Okay.
Barring 1-2 minutes, we will not resign more.
I'm ready to conclude my argument. As well as I have to prove some of the document leadership on the identical issue. It may take more than half an hour.
So let it come in the usual course. Yes. All right. Let us see what happens.
My lord.
Your lordship might have remembered. So out is out of the list. Your lordship, 2 matters your lordship has already heard and if reserved the judgment your lordship. Only section 8 of the GFT Act your lordship has repeated. These 2 matters of the OF mixed on send up ceremony those could not be taken up. And those matters are fixed up today. But it cannot be still your lordship. If it will be convenient or something. Can it be because it can be for subject lordship has already heard all these.
All right. It's coming on Thursday. On matter because we are parthered, huh? All right. But it is a parthered matter, I think. This bench is 20 Friday. It will come on Friday.
That's a may I pray. I think this bench is available on Friday. Because today so much of rush of matters with the lordship's bench. Can I pray for Friday so that it can be half an hour? My friend is saying we don't have to resign.
Item number
8. That 8. Yes.
All right.
Item 8.
Right at the top of the list. Half an hour, which is over my lord.
Friday usually it is not division based day. Only few matters will be listed.
My lord.
All right.
Deeply obliged.
Item 12 at page 12, item 9. Page 13, item 10.
My lord, item number 10 is a partheard matter, and in the last order dated 13th September, your lordship said me please to grant me liberty to mention this matter for upgradation. And I have also informed the other side. I have filed the written note of submissions along with the bullet point of arguments and the sequence of dates and events. My lord, I will take maximum 10 minutes. So this matter may can be taken up after the first item, that is fresh admission.
No. That you take up your matter, be there, please.
Page mentioning over.
Two fresh matters, read to 2J matters. Right is there for the applicant. Filing a memo, somehow it is not down. Can it be taken?
Not today.
No, not today.
I will be parliament to make a mention matter.
There are one CRL says a single matter.
out of the same criminal case, 2 CRLMC has been disposed of by my Lord Justice G. Satpathy. Now the determination is of my Lord Justice Ratha. So the registry is not putting the matter to anywhere. And that has
No, just go to Justice Chakraborty. According to the latest Supreme Court decision, tell them to register with Justice Chakraborty.
Earlier, my lord was pleased to allow, but due to the delay in time reporting, it was not being used. I pray
Yes.
My lord, in this case, I filed the writ appeal which was dismissed by the due to non-appearance of the advocate, my lord. Thereafter, I filed the CMPL. The CMPL was dismissed because there was a delay of 474 days.
Yes.
Thereafter, I approached the Honorable Supreme Court. Supreme Court directed that since the corona period has not been taken into consideration, this period may be considered and may be decided. I have filed the writ of interlocutory. My lord?
Have you filed the application?
Yes, I have filed interlocutory application.
My lord, press writ appeal, my lord.
It will go to the, who passed that order, final order?
Final was division bench, single bench matter. My lord's justice, my lord, Chief Justice, my lord, pass. CMPL was dismissed by the my lord.
Well, if it is a check up, no? Check up, appropriate bench.
Pardon, my lord. Press writ appeal, my lord. At its elections.
My lord, public interest litigation. Yediapalli Gram Panchayat unanimously resolved to construct a Kollana Mandap at Gopalpur village. Money was sanctioned by government. Work has proceeded to a great extent. Bill submitted but not paid. Now the opposite party number 2 BDO is trying to see to replace the construction of Kollana Mandap to another village.
All it will be taken up.
Sure.
Yes.
My lord, may I be permitted to make a mention? My lord, this is a writ appeal and it has been listed before your lordship, my lord, several times. My lord, on the last occasion, it was directed to be listed on 12th September, my lord. But it was not listed. And my lord, I'm the respondent and there is an order where the appellant is operating the petrol pump. I am severely prejudiced by that. And I only request for knowledge.
In the list.
Lord, on last 13th, your lordship directly this matter, PN matter to be listed today, but it didn't come. It is listed on 21st, my lord.
21st, okay.
Yes.
My lord, kindly pardon. Your lordship directed for listing the matter on 14th September, my lord. And same time, your lordship directed the state government to take instruction whether a post is lying vacant to accommodate the appellant, since person general to the petitioner has already been appointed. I pray your lordship 21st of May.
21st may not be possible, then the closest date will fix up the matter.
Next week, any date, your lordship?
27th.
Well, it is a single bench content matter. Content petition filed on 4th February 2022. And I have also filed 2 numbers of petition before this and I will go to listed this matter. I have challenged the order dated 21st September 2021. Another one, cancellation of the bail. I have filed the petition on 12th September 2022.
Mentioned before the appropriate.
I have already mentioned several times, my lord, but it couldn't be listed.
Go to the Deputy Registrar Judicial, ask him that I have asked you to appear before him. The Deputy Registrar Judicial.
Diploma.
Your lordship directed to leave this matter on 15th September. That is now listed, madam.
Just see. The state so many matters.
Your lordship, with the contempt appeal petition, section 19 of the Contempt Court Act. In the meantime, the deactivated 2 number 1 after another contempt application, appeal case got dismissed by the assignment bench, and one after another having different dates. Despite our last occasion, the said court has already CMPL also dismissed. The second CNTSC number 5/23 got dismissed. Then the CMPL chapter 8 rule 30.
What is the order that you are filing the appeal?
Order got dismissed CMPL, your lordship. And your lordship may change the bench any other.
No.
Your lordship.
No.
Without having any justifiable ground, they dismissed. Despite our several.
We cannot give you the bench of your choice.
No, your lordship. It is the prerogative of Chief Justice of Odisha High Court.
No, you're saying that since the judge has dismissed your earlier petition, he should be listed before another judge. For the first time in my life, I've seen this kind of a submission. Sorry, Mr. Counsel, you filed that it will be listed before the appropriate bench. Yes.
Mercy.
Sir,
Mentioning over.
sir, for the fourth time, I'm applying for the same cause, sir. Sir, I am not a professional, sir. I am also old fellow.
What is your case number?
Sir, 16195.
It is in the list today?
No, sir. For the fourth time, I am appealing for a.
Just you. Thursday it will come again because in between there are 2 holidays. Thursday.
Okay, sir, earlier children, no, sir.
Thursday matter will be taken up. You just attend at that on the day.
Okay, fine. Make on the list. Weekly list stress admission item number 1.
My lord, earlier I had made submission which was partly heard and I had served the copy to the OPSC, my lord. That is in clear violation of section 34 of the RPW Act. I had made submission, my lord, with that will.
The matter, my lord, first my kindly see the nature of a PIL. This case has been filed.
First, may kindly see who is the petitioner.
Yes.
And what is his locus standi, my lord? He has not even followed the Odisha High Court public interest litigation rules,
Yes.
which is framed. And it's a service matter, my lord. He has filed the PIL, my lord.
This is a prayer that you are taking actually.
My lord. His prayer is, my lord, why appropriate or direction for inclusion of all category of PWD shall not be included, my lord. I have got the, my lord, the notification, my lord, of the government of Odisha, my lord.
That is not under challenge.
My lord, that is not under challenge.
By the order number 1, the Honorable Court single bench has referred this matter as a PIL to this Honorable Court.
No, I am not on that aspect. There is certain limitation filing PIL about employment and education matters. Because these persons who are usually aggrieved by any decision, they are the competent to come to the court. PIL not for them. But if you say that this is not implemented and Mr. Tripathi says government has already adopted a policy and that policy you have not challenged.
I have not received that.
How you receive this? You have to do the minimum research for coming to the court before public interest filing the public interest litigation. Just show us the notice.
My lord.
What is it?
Give this Eligibility Act of
What is happening? Please. I have marked it and sent it, my lord. Let's may kindly see the other one which Justice Rath is holding, my lord. Their assistant judge and allopathy, my lord. Page 17, my lord. Let's may kindly see. Let's may kindly see page 17.
Yes.
Let's may kindly see the categories. One leg affected, my lord. OA, OL, and BL only. And let's may kindly see the advertisement. Which my lord and friend, my lord, had challenged. Annexure 1, page 12, my lord.
Yes.
Your lordship has seen the categories which have been there.
Yes.
That vacancy position, after the vacancy position, the categories have been earmarked, my lord. May kindly see OA, OL, and BL.
That is C.
33 is OL.
My lord, OA, one leg affected. My lord, all these things, my lord, are there. My lord and friend has not challenged it. He is, my lord.
This is a roster. How can you do that?
You know what, that is the category of the C, not B. And as per the section 34, all 5 categories.
No, the government has a power also to recalibrate things. Just come to the provisions of Act.
Page 18.
Government can also assess the
Page 18.
nature of the service and the reservation they will make. Come to the page.
बात कर चलता बात कर
You come to the proviso to section 34.
34.
B. Paragraph 3.
There is a two proviso. Come to the first proviso. Then come to the second. In your case, just you come to the subsection 2, proviso to the subsection 2, that is the appropriate provision for this case, that provided that if the nature of the vacancies in an establishment is as such that a given category of person cannot be employed, the vacancies may be interchanged among the 5 categories with the prior approval of the appropriate government. So they have already published a roster considering the nature of the job in their particular establishment. Unless you can challenge, the rationality is challenged before the court, we cannot grant you any relief in this petition.
My lord, in the rights of person with disability rule 2017 establishment.
Am I understandable to you? There is already this notification has been issued by virtue of resolution 3rd of December 2013. They have followed a particular procedure. If you are aggrieved by that, and they say they have shown the advertisement that has been issued is in observance of this notification. So unless the very basis is challenged, how can you interfere with this kind of an advertisement?
Let a copy of that be sought. My lord, let a copy of that be sought on me.
I am giving you the Gazette notification reference. It has been published in the Gazette 3rd December 2013.
My lord, thereafter the rights of person with Result Act came into force in 2016.
That I have seen it, but that also that provision is there.
That is the notification of 13, but the act is common.
No, obviously, this act, if any changes are required, then they will be made. If no changes is required in the notification, that may not be made in view of the new act.
My lord.
If you say that changes are necessary, you have to challenge the resolution.
Other categories is just light.
I understand. This limit of departure from the earlier provision is there. But you have to challenge because they have made a statement. I will record the statement of Mr. Tripathi that the advertisement is published in view of this resolution dated 3rd December 2013.
My lord. Let a copy be sought so that I can answer. My lord.
All right. They will not serve a copy to you.
Okay.
It is your duty to find out. Then what you do, want to take back this writ petition or you have to continue the writ petition?
My lord, the last date is it today? 18th. Today is the last date for application for the post of recruitment to the.
We cannot do any in view of this notification. We cannot interfere. You can challenge it. If anything, that they are in violation, but because why are you so late? I don't know. Advertisement was published in is a long ago. It's almost. What is the date of the publication? Is it before the month of August? In the month of August 2023. Now think of actually, I thought the roster is not in existence. Then there would have been a situation. I think you should file a fresh writ petition because all these matters you have to take into consideration. You have to make a comparative study of the old act and the new act and whether this resolution is correct or not. All these are new grounds for you. What to do you have to decide withdraw the petition or you continue with the petition.
Come tomorrow.
Time is taking.
Let it come tomorrow. I'll get the copy.
No, it will not come to. Let the matter be listed on 5th of October 2023 at the request made by Mr. You are Mr. Das.
Yes, my lord.
And K. Das Learned Council appearing for the petition of Mr. B.P. Tripathi Learned Council has appeared for the Orissa Public Service Commission.
Item number 2.
The pair of Natmanda is not being taken up by Orissa since 5 years, my lord. I've given a report that
Mr. Mohanty, that on the other day, whether it is you that the
I've given a
construction
report.
has been already considered by the
Yes, my lord. Yes, my lord, I have already.
You are the administrator?
No, administrator. That is so far as your lordship says, that is in or Ratnamanda.
No, Ratnamanda is separate. This is also an old matter. This from 2016 the matter is
For several conservation work.
Natmanda, after the completion of the Natmanda, completely safe because government completed. Where are we standing from 2018 till by law? We required. We working on continue work. And they said there is no danger, nothing.
Core committee constituted by some experts, and the meeting was held on 26/6 in this month. 26. What my Lord Senior has submitted.
26th of June this year.
26th of June this year, my lord. And I will give the report that copy you take it. My lord, senior, basing on that report, submitting that there is certain danger to the amount of bill.
Always.
Thank you. Core committee. That is the core committee. Meeting is I will see the meeting is with me.
But the issue that Mr.
We are kindly to page 3 of this.
Three only. Yes.
Page 3.
Yes.
Page 3 at Natmanda.
Serial number 3 you are referring.
Yes. Page 3. Natmanda.
Serial number 3 you are referring.
No, Jagmohan, then Natmanda. Page 3.
It is the detailed structural design of the cracked stone beam. That is the you are referring to.
Natmanda.
Natmanda. I am coming to Natmanda. Come below. First, 2,
Serial 3.
That 3.
Yes.
That's the first case.
What happened in the meeting that was convened on August 2023?
My lord, in that
What
meeting,
happened in the meeting of August 2023?
awaiting the report of the design from the IIT Madras. And
Okay.
detailed report,
Has not been received from them.
no, not received from them.
So you have to expedite the matter. It is your responsibility.
This matter of same,
Now
we
we are
have
the one-
already communicated within by this week, we will obtain the design and direction will be given that they should give it when they will start, when they will complete. Similar work has been completed in Mundija Mandir. Consultations.
I got that you have directed them to expedite the matter
Yes, ma'am.
and final decision shall be taken by 15th of October.
Decision, my lord.
Final decision, 15th of October, because you have to float tender and other thing. because
Yes,
you are
my lord.
Bringing these outside agencies for the construction purpose. Retrofitting cannot be done by one and everyone. It is a specialized job. Mr.
That is
Mohanty,
to-
this 15th of October, we are fixing it. 15th of October, we are fixing a deadline for taking the final decision,
Yes,
right?
Yes.
E.R. N.K. Mohanty, learned Micah's theory appearing in this court has produced before us the minutes of the meeting of ASI Technical Expert Core Conservation Committee held on 22nd June 2023 to draw attention to the suggestion made in the core committee in respect of cracked stone beam in the Nata Mandapa. For better reference, we extract the observation and decision of the said core committee, (3). Detailed structural design for the cracked stone beam for introduction of stainless steel box beam or bonded plate anchoring in U-shaped retrofitting technique will be assigned to IIT Madras and placed before the expert committee for finalization of the design. Both the option will be explored and appropriate action will be taken as early as possible by following the archaeological conservation policy and norms. The expert committee meeting in this regard will be convened in the month of August 2023 to finalize and expedite the conservation work. The ADG CON also gave emphasis for minimal intervention in the monument to retain the aesthetic and architectural beauty of the monument. You are Mr. D.K. Mohanty,
C.K. Pradhan.
Mr. C.K. Pradhan, Learned Counsel appearing for the
Yes, yes.
ASI, has stated that the core committee did not receive the detailed structural design from the IIT Madras, and as such, no decision could be taken as proposed. Stop. Stop. Mr. Mohanty, Learned Counsel has submitted that the crack in the stone portends danger, and as such, it's appropriate action for conservation and scaffolding cannot wait. Stop. We have no disagreement with the submission with Mr. Mohanty. Learned Amicus Curie. Where is Mr. Mohanty is coming? Right, Amicus Curie. So we direct the ASI to impress upon the IIT Madras to have the detailed structural design as proposed in the meeting dated 22nd June 2023 as reproduced before. Stop. Be that as it may, the final decision and choice has to be taken on or before 15th October 2023. Let the matter be listed on 19th October 2023. So a report shall be submitted by the ASI how they have complied this order. A copy of this order be supplied to Mr. Pradhan Learned Counsel in the court of the day. A copy of the minutes of the meeting held on 22 of the ASI core committee, ASI meeting of the technical expert core committee, core conservation committee is referred before, is taken on record. Just a photocopy and thereafter returned to you. The original will be returned to you.
Yeah, I've got a copy.
Already then it will be taken on record. Okay. Yes.
May I please, I'm applying for the petition. Till then, the protection of the beam must be done by the ASI.
It is there. We have done that.
Already monitoring.
Yes, it's taken now. So no direction is required.
Item number 3.
But so far, I will pardon item number 2, that matter connected item, sub-item 3. Sub-item 3, your lordship related to Ratna Bhandar.
Yes.
Say another writ petition is pending for lordships. It's 20481. So last occasion, lordship said that this time I will invite your lordship's attention. So 20481, it may be connected to that. Maybe detached from this. It's not similar to.
It is not be detached.
It is to be detached, my lord, from this lot.
No, all these 3 matters are tagged up long since. And with Konark Mandir and.
अरे ठीक है चिता हो सर पड़ोस की भूल ही it is related to Ratna Bhandar. It is not 20481 of 23 maybe tagged with that.
I'm not getting it.
It is not listed.
It is not listed. You want it should be listed with this, but this is
I pay this sub-item number 3. Let it be there.
Yes.
The item 3.
Item 2, 9792, we have filed already rejoinder, copy also sought, in item 2, the third matter.
All right, you record it. Item number 2. Rejoinder has been filed by one that just you filing. Let the matter be listed also on date, same date. Yes.
Well, I have given a compilation. Does your lordship have it? These were the act and the rules and other documents. Well, while they find out the compilation, would your lordships take the MMDR Act minutes? Just to recapitulate what is this case.
Compilation means written note of submission.
Small compilation containing the acts and the rules. It was under a memo. The heading was a memo. It has an index and it has about 193 pages. Sit. Your lordship may just keep it. I will start with the act minutes.
Okay.
If my lords kindly turn to section 10, capital A.
You are referring to
section 10A 2C. Lord, that is this case, whole case about.
Yes.
My Lord Justice Author has 10A 2C. The boy does not get MMDR Act.
MMDR.
What is it? Could be page 20, my lords, if we are holding the same book. Okay. Section 10, my lord, capital A.
Yes. The rights of the existing concession.
My lord, my lord.
My Lord Justice Atha has it, minutes. Kindly see page 21. It should be at page 21 if we are holding the same book. My Lord, we are concerned here with 10A2C. It is the case of my learned friend that since there is an approval under section 5, they have a right under 10A2C. Your Lordships are considering that. Let me place 10A2C. Where the central government has communicated previous approval as required under subsection 1 of section 5 for grant of mining lease. My Lord Justice Atha has that section 10A2C, yes. Where the central government has communicated previous approval as required under subsection 1 of section 5 for grant of mining lease, or your Lordships are not concerned with the letter of intent, your Lordships must skip that, has been issued by the state government to grant a mining lease before commencement of the MMDR Act 2015, the mining lease shall be granted subject to fulfillment. Look, this is, your Lordship may kindly underline this, subject to fulfillment of the conditions of the previous approval within a period of 2 years from the date of commencement of this act. So therefore, if you have a 5-1 approval, if you have fulfilled the conditions of previous approval, that is 5-1, within a period of 2 years from the date of commencement of this act. So this this amendment came on 12th of January 2015. Your Lordships will see that at the foot of the page. Yes. So 12th of January 2015 is the amendment. C says that if you have an approval under 5, then within 2 years, you will be granted a lease if you fulfill the conditions of the previous approval. Am I clear, my lords? Yes. Now kindly see, my lord, what is the previous approval? And that your Lordships will get, my lords, at page 45 of the writ petition. Annexure 2. My lord, page 45 of the writ petition. Yes. Should be at the beginning, my lord. Yes, I got it. Yes. My Lord Justice Atha is looking at it. Page 45, Annexure 2. 17th July 2020. Grateful. May I read it very slowly? I am directed to refer to your letter number so-and-so, dated so-and-so, on the above mentioned subject and to convey the approval of the central government under section 5(1) of the MMDR Act 1957 to the grant of mining lease for iron ore over an area of so-and-so in village so-and-so in favor of Messrs. Odisha Sponge Iron Limited for a period of 20 years. Paragraph 2 is a little important. Before allowing grant of mining lease, the state government may kindly ensure the compliance of the amended provisions of the Act and the rules. That will actually read MMDR Act and the MCR rules. Yes. Because these are the two acts and rules in contemplation. And other applicable acts and rules, including Forest Conservation Act 1980, Environmental Notification so-and-so as amended by the MOEF. So therefore, my lords, 5(1) says that you should have an approval, and if you have fulfilled all the terms and conditions of the approval, some kind of a right is vested in you for a grant of a mining lease. And my lord, it is my case, A, that this approval has not attained a finality, and I will demonstrate that. Because correspondences regarding reconsideration is continuing, A, and B,
In any event, the provisions of the Act and rules, that is the MMDR Act, which contemplates of a mining plan under section 5(2)(b), that is not there for a non-captive lease. The mining plan is not for a non-captive lease. My lord, I must tell your lordships, what is this captive and non-captive? My lord, ordinarily, all mining leases are meant for non-captive. However, if under section 11(3) of the Act, the state chooses to give a lease to an industry for its captive consumption, then the state says so in its recommendation, as has been done in this case, and therefore it intends to insert a captive clause in the lease.
Yes.
Now, my lord, for the purposes of inserting a captive clause, there has to be an approval from the central government under Rule 27(3) of the Mineral Concession Rules 1960. Your lordship may kindly note this, my lord. For inserting a captive clause, there has to be an approval of the central government under Rule 27(3). Your lordships have seen the recommendation.
Yes.
The recommendation says the requirement of a present industry and future industries is X. The ore that you will require for 50 years is a multiple of 2, that is, let us say 2x. This area contains 2x. It commensurates with your requirement, and therefore I am granting you this lease. There were 18 other applicants. The state did not consider their case because they did not have a requirement of captive. So, my lord, it will be my endeavor to satisfy your lordships that 17 July 2002 is not final, A. B, it is not an approval in terms of my recommendation. And C, in any event, they do not have a mining plan, or they did not have a mining plan till 17th of January 2017, which is 2 years.
Yes.
Lord, one more point I wish to make, that between the petitioner and the state government, there was never an issue as to whether the lease which the state intended to give and which the petitioner intended to take was always a captive lease. Look, this is very important. What I intended to give was a captive lease, and what he intended to accept was also a captive lease. So it is not as if it was ever their case that their lease was not to be hedged with a captive condition. Your last date, my lords, I had taken your lordships to page 77 of the writ petition. That is where we had closed. Annexure 12, my lords, page 77.
Yes.
My lord, what happened was that after the 2015 amendment came,
This light is glaring at my eyes. Just 1 minute.
Yes, yes.
Vijay.
But actually the light is always that side.
And you also enjoyed his lighter comment.
I know. Very dear friend.
Yes.
So, my lord, page 77, your lordships look at. Your lord, when 2015 amendment came, your lordship knows, my lords, all pending applications were said to be ineligible.
Yes.
And 2-3 classes were saved. and saved for a period of 2 years. There was a set of rules also. Now that rule is in that compilation which your lordships have.
Yes.
And if my lords kindly turn over to page. Too late. Speaking it out. If my lords kindly sees page 190 minutes of the compilation, it starts from, but if your lordship sees page 191,
yes,
there is something called at the bottom of the page called Rule 8. My lords have it, my lords.
Right under the provisions of clause.
Rights under the provisions of clause C of subsection 2 of section 10 capital A. We are concerned with the 10 and 2C case.
Yes.
So, I don't think it's in that book, my lords. It's in the compilation. So, if your lordship sees the applicant in whose favor, my lords have it?
Yes.
At the bottom of the page. My lord Justice Author has it, my lords, in the compilation. Kindly see A, my lords.
Right.
The state government has issued a letter of intent. We are not concerned with that.
Page 191.
But online, achhi. Is it there? Is there a soft copy with my lord?
It is there.
Okay. So if you, my lords, kindly sees page 191 and then kindly go to 192 minutes. We are at B because this is their case is that we have a prior approval.
Yes.
The central government has communicated the previous approval in writing before January 12, 2015 under subsection 1 of section 5 for the grant of a mining lease or mineral specified in part C of the first schedule to the Act. So what he should do? So if my lords just sees the previous page, the applicant in his favor, this is there. So now what he intends to do is, what is required to do, shall submit a letter of compliance to the state government of the conditions mentioned in the letter of intent or conditions mentioned in the previous approval granted by the central government as the case may be, and the state government shall send an acknowledgement of receipt of the letter of compliance to the applicant in schedule 2 within a period of 3 days from receipt thereof. After receipt of letter of compliance, the state government shall issue a grant order, shall order for grant of the mining lease within a period of 60 days from the date of receipt of such letter, subject to verification of fulfillment of the conditions mentioned in the letter of intent or previous approval of the central government as the case may be. So therefore, my lords, what he is supposed to do, he is supposed to make a representation that I have complied with all the terms and conditions, and the state government is required to verify them. And if it finds that they are there is compliance, it will then take the next step. Now kindly see, my lord, page 77, which is annexure 12 to the writ petition. So let us see, my lords, how he complies with Rule 8.
Yes.
Now, my lord, kindly see the date of this letter. This is 17th of December 2016. Now, kindly see subject. Compliance report on the terms and conditions issued wide letter number so and so dated 27/9/2004 under Rule 8(1) of the MCR 1960 in respect of so and so. My lords have it, minutes?
Just a minute.
I'm sorry. Page 77, annexure 12.
Yes.
May I read it again, Millards?
No, it's already.
Yes. So kindly see this letter. We had already accepted the terms and conditions issued by your good office on 27/9/2004. We are submitting the compliance report on the above terms and conditions, which is enclosed.
Yes.
27/9/2004, my lord, had a condition of a captive clause. I will not bother your lordship with that document because it is admitted in this letter.
Yes.
It is kindly requested to issue acknowledgement of receipt of compliance to us in Schedule 2. Kindly refer to so and so within 3 days of submission of this letter. Now kindly look, my lord, at the foot of the page is the heart of this case. What I am saying you don't have a captive approval. Now what are they saying? Let us see how they understood it. Now the CC says, Secretary Mines, Ministry of Mines, Government of India, the authority which granted the approval, with a request. So now the petitioner is requesting to kindly look into the matter and facilitate us in executing the mining lease with the government of Orissa, as we have already accepted the condition of captive clause with the state government. So, my lord, it has been my case that your lease deed should have a captive clause. It is the petitioner's case also that please grant approval for a captive clause to facilitate grant of mining lease.
All right.
My lord, in all fairness to the petitioner, he acted bona fide. He knew that this was a recommendation for captive. He knew that the lease was being held up because there is no captive clause. He is now writing to the government of India, please facilitate the execution by allowing us to execute a lease deed with a captive clause for which there is a prior approval required under 27(3).
Yes.
Now your lordship may then go.
Next should be the one.
My lord, if your lordship now turns to page 231. My lord, 231 annexure D by 1 to my counter affidavit. My lords have it.
Just one.
Yes, yes.
Yes.
My lord, your lordships has been shown a document at page 223 by my learned friend. Page 223, this document was read out to your lordships. This was a meeting conducted by the Director of Mines.
Yes.
And in that, if my lord sees, my lords, several applications were considered and one of them was the petitioner. Disposal of applications under 10A2C. My lordships have it there. And kindly see, my lord, one is Orissa Sponge. And the director had recommended that you process the application. Now kindly see page 231. This report of the director was now placed before the state government. And 234 annexure D by 1 is the minutes of the 9th meeting of the interdepartmental committee held on 26 December 2016 at 4 p.m. in so and so conference hall. My lords have it, my lord. This is a subsequent meeting. And in that meeting, my lords, the meeting was chaired by so and so, committee was appraised about the background of the matter, the recommendations of the each meeting of the committee, the action taken pursuant to thereof. The committee pursued the agenda, perused the agenda placed before the Steel and by the Steel and Mines Department. The meeting of the screening committee to consider cases for grant of mining lease under section 10A2C and 10A2B were held on so and so. The committee has furnished the recommendation. The one your lordship saw in the previous page. Now, what is the decision? Your lordship, me, Roman 1 is the petitioner. The screening committee has recommended that in view of the compliance by the applicant and taking into consideration that the applicant has established an industry inside the state, thereby contributing to the growth of the economy of the state, government may issue grant order in favor of the applicant under section 2, under rule 8.2 of the so and so, subject to verification of so and so. Kindly see the next page. The interdepartmental committee noted that the applicant has not submitted compliance to conditions so and so and so and so of the letter of intent, terms and conditions issued by letter dated 7546 dated 27/9/2004. Though it has accepted the said terms and conditions, the conditions of clause so and so to so and so relate to investment by the company within a definite period specified therein. It was also noted that the sponge iron plant of the company is closed since 2012. Hence, the committee did not agree with the recommendations of the screening committee. The interdepartmental committee therefore recommended that the applicant be asked to submit a full compliance with the terms and conditions of the letter of intent, more specifically so and so. Applicant may also be directed to inform the conditions regarding so and so. So the interdepartmental committee says that, look, they have not accepted our terms and conditions. The industry is closed since 2012. Now we are having this meeting. Which year?
6 December 2016.
In 2016. So 4 years that factory is closed. So therefore, unless they comply with the terms and conditions, we cannot go any further. Now, my lords may kindly see page 240.
Company is closed from 2012.
See, my lord, before even this recommendation was made, they already had a plant. My lord, this petitioner already had a small plant. They said we will expand this and put up new plants. Now, kindly come to page 240. Annexure E/1. So, in compliance to his letter under Rule 8.1, saying that there has been compliance, your lordship saw me lords under Rule 8.1, he had to give me a letter and I had to examine and then find a reply. Now, what is the reply that your lordship will kindly see me lord, page 240.
Yes.
So, my lord, I reply to his letter of under Rule 8.1 by saying this. To Vice Chairman so and so, my lords, ML application of Orissa Sponge so and so, with reference to the subject cited above, I am directed to say that full compliance with the terms and conditions of the letter of intent, more specifically under so and so thereof, may be submitted to the department for consideration of ML application of Orissa Sponge Iron Limited for iron ore over an area of 459 hectares in village so and so of Keonjhar district by the government under 10A2C of the MMDR Act, read with Rule 8, you are also directed to inform. So, my lord, under Rule 8, he gave me a compliance report. I said your compliance report is not satisfactory, and therefore, in my humble submission, my lord, the matter ended there. Your lordship may only note, my lord, 7/1/2017, which was under Rule 8, was not challenged. And the reason why it was not challenged, because they knew by that time the captive clause has not come. They had requested for a captive clause to the government of India. on on 17th December 2016, Lord, 17th of December 2016, they had requested the government of India at the foot of the page that please grant us a captive use, that the lease is for captive use to facilitate grant. Now, on 7th of January 2017, when I write to them, they do not question this order. They should have said that, look, we have complied with Rule 8. Please grant us the lease. Nothing happens. You know, the next document, my lords. That's not right. Yes. Now, my lord, if your lordship sees, I want to show your lordships two letters. One is page 241. Would your lordship just give me 2 minutes? Yes. My lord, if your lordship sees first page 66. This is on the point as to whether the 5-1 approval on the basis of which the present writ petition has been filed has attained a finality or is it under reconsideration. And that your lordships will see at page 66 minutes. Yes, sorry. It's there later. Which one is Page 66. My lord. 66. Your lordships will only note, my lords. 66, annexure 9. Yes. Lords may kindly see 62 and then we will come to 66. Page 62, my lord. Yes. Is 1st of August 2015. The state government writes to the central government and kindly look at the subject. Consideration for imposition of special condition under Rule 27(3) of the MCR 60 in respect of the mining lease for iron ore over an area of so and so to be granted in favor of Orissa Sponge. So I am writing to them that you have granted an approval. Consider insertion of a captive clause in the lease. And my lords may kindly turn to page 64 minute. I will not trouble your lordships with the whole letter. Paragraph 8. Thus, the special conditions regarding expansion of the existing plant, my lords have 64, page 64. Thus, the special conditions regarding expansion of the existing plant from 1 MTPA to 3 MTPA and setting up a 8 MTPA plant has not been approved by the central government. However, the applicant company has accepted the conditions. Beside MOU, if lords may skip all that, my lords. Kindly see the last paragraph. It is therefore requested once again that the proposal of the government of Orissa for imposition of special conditions returned back with the central government in by its letter dated so and so, dated 4th July 2005 may please be reconsidered. So I am writing to them, please reconsider. And now your lordship may kindly see page 66. Yes. Here are two agencies, my lord. Under the statute, I am the recommending authority, they are the approving authority, and at page 66, they reopen it for reconsideration on 20th of January 2016. Not lordship, this is important. Yes. So 20th of January 2016, annexure 9, page 66, the central government does not say that that issue has attained a finality. It now seeks information from me. I am directed to refer to the government of Orissa letter dated so and so. Request you to provide the following status of the target milestones listed in the MOU, to give the present installed and pledged future plant capacity of the requirement of ore for next 50 years, details of reserves of the said area with level of exploration as per stipulation in so and so, to specifically state the reasons for inordinate delay in processing the plant application. So now they are saying, you give us these informations. And my lords may kindly see the very next page is a detailed reply by the state government on 2nd of December 2016. I will not trouble your lordships with the whole letter, just that the correspondence continued, and I wrote to them why I require a captive clause.
Yes.
My lords may kindly now turn to page 241, annexure F/1.
Yes.
This is another letter written by the Government of India, Ministry of Mines. Kindly see this, my lords. To the Secretary, Government of Orissa, Department of Steel and Mines, Bhubaneswar, imposition of special conditions to the grant of mining lease for iron ore over an area of so and so, village so and so in favor of Odisha Sponge. I am directed to refer to the Government of Odisha's letter dated so and so on the subject noted above, and to say that the status for consideration of the MOU may be detailed by giving the action taken by Government of Orissa after the application of the project proponent for extension. The following points may kindly be clarified: whether extension of MOU by more than 7 years is provided in the existing MOU, and if so, whether it is legally permissible, and the existing terms and conditions in the MOU are still relevant and proposed to be issued, whether OMC or Ashimi area is Orissa Sponge. Future installed capacity has been arrived at by the state government against the requirement of work for next 50 years, and satisfying them, please provide documentary evidence. You are requested to provide the information to enable the ministry. But this last line is very important. To enable the ministry to process the case further. In my humble submission, my lord, this is a clincher. So the government is now saying, Government of India is now saying that we give us these informations to process the case further. So 5-1 has now been reopened. You know, the statutory authority under the Act who recommends the lease is telling the Government of India, look, my recommendation was for a captive clause. Without a captive clause, I can't go ahead. And then Government of India is saying, you give us these information regarding the industry, regarding the installation, to process the case further.
Yes.
So, my submission therefore is, and your lordship may kindly consider this, that the correspondences with the Government of India at page 66, right? At page 66 and at page 61, at page 241,
Yes.
clearly suggests that the central government has reopened the 5-1 approval.
Yes.
From the document your lordships have seen, at page where did we say? At page 77, and I will not trouble your lordships notes. Page 77, the petitioner himself writes to the Government of India by forwarding a copy of compliance, saying that please grant us a 27(3) approval for insertion of a captive clause. And this is way after, years after, the so-called approval under 5.1 was given. So in my submission, these three documents demonstrate the intention of the parties that the lease should have a captive clause, and B, Government of India clearly at page 21, 241 is saying that we have to process this case further. So there is no 5.1 approval as on that date, and nothing has happened thereafter to say that I have a prior approval under 5.1. In my submission, that 5.1 approval is under reconsideration, and therefore no rights under 10A2C.
That's all.
My alternative argument is, my lords, assume it is let me argue against myself. If your lordships were to hold that there was a 5.1 approval, then 5.1 approval on 10A2C also said that you must comply with all the terms and conditions. Now just kindly see the mining plan. Page 87, your lordships have seen the other day, my lords, that there is a provision called section 5.2b under the MMDR Act. Would your lordship just have a look at it for a minute, minutes?
5.1b.
5.2b of the MMDR Act 1957. Let us look at the book. Yes. If my lords are pleased to turn to section 5, lords, in the book.
Yes, yes. 5B is regarding the mining plan.
Correct. 5.2b.
Central government.
5.2b. I'm grateful. 5.2b, if my lordship sees, not 5.2 says, no mining lease shall be granted by the state government unless it is satisfied that. My lords have it, my lords.
Yes.
Kindly see, my lord B. There is a mining plan duly approved by the central government or by the state government in respect of such category of mines as may be specified by the central government for the development of mineral deposits in the area concerned. So, my lord, therefore,
Yes.
the 5.1 approval said you must comply with all the acts and the rules. Now, 5.2b says that the condition precedent for granting a mining lease is there must be a mining plan duly approved.
Yes.
Now, kindly look at the mining plan. Let us see what kind of a mining plan they have. And that your lordships will find, my lords, at page 87.
Where is it?
If my lordship sees page 87, my lords, this is 24th of March 2005.
Yes.
If your lordship sees, words, subject approval of mining plan of so and so in favor of Mrs. Odisha Sponge. That is the subject. My lords have it, my lords. Subject approval of mining plan of Malangtoli iron ore deposit over an area of 459 hectares in Keonjhar district of Orissa, state in favor of Mrs. Odisha Sponge Limited, submitted for grant of mining lease under Rule 22 of the MCR.
Yes.
You know, this mining plan is based upon my recommendation. Your lordships had seen Rule 22. That is the rule under which a recommendation is made. And now your lordship may see, my lord, what it says is, it lays down several conditions, and if my lords are kindly pleased to come to page 89. This is the last condition. My lordship have it, minutes. Page 89, Roman 10.
Yes.
The approval of mining plan is subject to compliance of the terms and conditions while item number 12 to 17. And I will show that to your lordships in a minute, minutes.
Yes.
And what is very important is, the lordship may underline and two of the state government's letter number so and so dated 27/9/2004. And what is critical is not the next 3 words before execution of the lease deed.
Yes.
So the mining plan now tells me that before you execute the lease deed, the lessee must satisfy ABC. And what is critical is, and two of the state government letter dated 27/9/2014.
Okay.
Now kindly see that document note. It's at page 52.
But according to them, they have complied all the conditions.
Well, that is, your lordship will see that. So mining plan says that this has to be complied. My lord, may I read that line again? Page 89. The approval of mining plan, my lordship, my lord, is subject to compliance of the terms and conditions stipulated by item number 12 to 17 and 2 of the state government letter. To this para 2. Para 2 of the state government letter dated 27/9/2004 before execution of the lease deed. Now let us, my lord, see whether this is complied or not complied.
Yes.
And that your lordships will see, my lord, because the 27/9/2004 is at page 52.
Connection 4.
Yes, my lord, grateful. So what is this, my lords? This is the terms and conditions of lease which was given to them by the state government. And the the mining plan refers to this letter. Your lordship may see, subject, application dated so and so. Sir, I am directed to inquire whether you accept the following terms and conditions that would govern the grant of mining lease in respect of so and so. Lordships have it, minutes. Now let us see the mining plan referred to paragraphs 212 to 217. Mining plan cottage. If your lordship just see, my lord, 87, 89, page 89 referred to 12 to 17 and 2. No, am I right, my lords? Page 89 referred to item numbers 12 to 17 and 2. So let us see what is 2. What is 12 to 17? My lord, 12 your lordships will get at the bottom of the page at page 53. Twelve is at bottom of the page, my lord.
What is your page number?
Page number 52, it starts, my lord. 27/9/2004, annexure 4.
And now you're referring from?
I am referring to page 53 at the foot of the page, Roman 12.
Yes.
Because what we saw, my lord, the mining plan was subject to fulfillment of 12 to 17 and para 2 before execution of the lease. My lord, am I clear, my lord?
Yes.
Now kindly see the assignment is subject to the condition that the company shall undertake expansion of existing sponge plant unit at Palaspanga and proposed Bamra project should be specified. So this said that you have to expand and put up a new plant. Now, if only you do that, then the mining plan says that you have to do this before state executes a lease. One can argue that without the lease, how will you do it?
So ultimately, it boils down to whether these conditions that you have put forward,
yes, my lord,
have been firstly accepted by that and then complied.
My argument is twofold.
Yes.
A, accepted.
Yes.
B, not complied. And C, mining plan which says that before execution you have to do all that, not challenged. One could have gone to court and said that, look, I don't accept this mining plan.
Yes.
Because I don't have a mine where you expand. Could be. But that is not his case, because the lordship saw, even after the amendment, they are writing to the government of India that please allow a captive clause to be inserted. Now, whole of this not done. Now, kindly see paragraph 2.
Now, what do you propose now?
No, I propose nothing.
I'm not obstructing. You just want they should comply with the clause.
No, I'll tell you what
You cannot. That is the issue.
No, I'll tell you what why.
Because of the 2 years.
No, because now the law has been further amended. There's a section called 10A2D.
All right.
Which amendment has come, my lords. On 28th of March 2021, there is a new amendment. Not challenged. So 2015 amendment said that you have to comply within 2 years and kindly look at 10A2D. The submission is that the window of 2 years has elapsed in 17. The parliament steps in 2021 and under 10A2D, lordships have 10A2D minutes. Just after C in that book.
Yeah, this book actually, amendment has not been incorporated. In your compilation, have you quoted it?
My lord, can I hand over the book if your lordship don't mind? Dear. Yes, sir. If my lords have 10A2D, my lords, and your lordships have to read it with the last 2 lines of 10A2C.
Yes.
Kindly see, my lord, the last 2 lines of 10A2C says, within a period of 2 years from the date of commencement of this act. So that takes us to 17th of January, 2017. So the parliament waited till 2021. And in 2021, they insert D to say, in cases where right to obtain license or lease has lapsed under clauses B and C, and they will lapse with the after 2 years, such areas shall be put up for auction as per the provisions of this act. So my submission to lordship is this.
That you have very emphatically stated.
Yes, madam.
You have not taken any decision, and this matter is still under consideration, and consideration is still.
No. I said Government of India granting of approval under 5.1, that was under consideration. And in the meantime, the statute has to be given full play. 2 years lapsed. Now, after 2 years.
No, it says that in cases where the right to obtain license.
Yes, my lord.
Has lapsed under clause B and C.
Here is the case of C.
C.
And C said 2 years. My lord, what was given under C was a window of 2 years to get this whole thing done. And admittedly, my lords, There is no mining plan on which it can be given. Assume, my lord, the 5-1 is valid. Where is the mining plan? Your lordship saw that this mining plan. So once 2 years goes,
So 10 ED will come into operation.
operation of interception. My lord, your lordships are holding page 54. So your lordship saw in that 10 to 17, 12 to 17, and also on para 2. Am I right, my lords? In that mining plan, there was also a reference to para 2. If your lordship sees page 89 minutes,
Again.
89. That's my mistake. No, I should have correlated it there and then. 89 said items 12 to 17 and 2. And 2. Your lordship got it, minutes? I'm sorry.
Yes.
So it said the approval of mining plan is subject to compliance of the terms and conditions stipulated so and so.
That you have read.
Yes. Now para 2 has not shown to your lordships. Kindly see page 55.
Page 52.
Page 52 it starts. The relevant page is at 55.
Yes.
Kindly see, my lords. Para 2, the conditions stipulated in so and so are subject to approval of the Government of India under Rule 27.3 of the MCR. What is 27.3? Captive clause. And kindly see, my lord, this was accepted by them at page 77. No, not this one. The format. And if your lordship sees page 56, page 5-6, whether they accepted this or not. Your lordships asked me a very pertinent question. Whether these conditions were accepted by them or not.
Yes.
Kindly see page 56. Annexure 5.
5 or 4?
My lord, Annexure 5 is page 56. My lords have 5 minutes. Odisha Sponge, application so and so. Please find enclosed the duly filled in form of acceptance of the terms and conditions offered by the state government of Orissa in your letter referred above in connection with grant of mining lease so and so. And kindly see page 57.
Yes.
I so and so, Managing Director of Odisha Sponge Limited, the legally authorized person to communicate the acceptance on behalf of the company, to hereby accept all the terms and conditions with the Steel and Mines Department dated 27/9/2004. I do hereby also agree that I shall abide by all the terms and conditions.
Clause?
My lord?
Which clause you are reading?
I am reading page 57, form of acceptance of the terms and conditions. Just the very next page, minutes. Lordships, have it, minutes. Page 57. Your lordships asked me whether 27/9 was accepted by them. If my lords have page 57,
yes.
form of acceptance of terms and conditions offered by the state government of Orissa in their letter dated 27/9/2004, subject to which mining lease is proposed to be granted to Messrs. Swens. Correct words. Now let me read this. To A.K. Sahu, Joint Secretary, Department of Steel and Mines, Government of Orissa, Bhubaneswar. I, Prasanta Kumar Mahanti, Managing Director of Orissa Sponge Limited, and the legally authorized person to communicate the acceptance on behalf of the company to hereby accept all the terms and conditions laid down by the state government of Orissa by the Steel and Mines Department dated 27/9/2004. I do hereby also agree that I shall abide by all the terms and conditions and provisions laid down now and as amended from time to time in the Mines and Minerals Regulation Development Act 57 and the Mineral Concession Act Rules 1960. I request the state government please to issue order granting the ML at an earlier date. So there was complete acceptance.
Yes.
Now, my lord, this letter read with page 77, which is post amendment of 2015, makes it abundantly clear that both the parties were of the opinion and understood that without a captive clause, this lease can't be granted. Because this lease was meant to be a captive lease. But I will show one more affidavit and I'm done with the facts. There is one document at flag M. Your Lordship must be wondering, why I am laboring so much in this.
Yes.
Your Lordship knows that these are very precious minerals, and that is why 2015 amendment came, and I will deal with that. And I am a custodian. In 2015, amendment said that now let us depart from this grant of leases on first come first basis. You pick up some applicant out of 4. You only get royalty in exchange of granting leases. So they said, let's move to auction regime.
That's decided already.
Now, what has happened to Orissa after we have entered the auction regime? That your Lordships will get from that affidavit, which is at flag M. Flag M, paragraph 8.
Yes.
My lords have page 3 of that affidavit, flag M, if your Lordships have it.
Yeah, to Mumbai.
Yes, my lord. Flag M, Mumbai. This was filed on 22nd August 2023. It's at flag M, my lord said. My lord, the Chief Justice does not have it.
Yes.
Kindly see, my lord, paragraph 3, page 3, paragraph 8. That it is profitable to mention that in 2021-22, during which the mining leases were put to auction, the state has earned a revenue of 49,859.12 crores, whereas in the year 2019-20, when auction regime was not in effect, the state has earned a revenue of 11,000 crores.
You are reading from?
I am reading paragraph 3, page 8, flag M.
All right.
I'm sorry, para 8, page 3, flag M.
Yes.
Now, this is 39B. This is public interest. And this is what, my lord, 2015 sought to achieve. And your lordships will be surprised. The auction rate has gone beyond 100%. Earlier, we used to get some royalty under the old act. Now, on auction, my lord, your lordships will see, my lords, that public exchequer has gained almost 4 times. And as we go on optioning more and more leases, my lord, I am a trustee of the people. So 2015 sought to achieve something different. Therefore, they said, for a period of 2 years, we will allow whatever is there. Otherwise, 10D said everything should go to auction. Now, my lord, just a few judgments, and I will quickly close, my lord. Your lordship may see in my compilation, and I will not trouble your lordships much. Kindly see page 7 of my compilation. This is the bill for the 2015 amendment. Page 6 of the compilation. My lords, are page 7, my lords, of this compilation. Yes. Kindly see paragraph 3, statement and objects of reasons. The MMDR Act is the central act which governs the development of the regulation of mines and minerals. I will not trouble with your lordships all that. Kindly see 3. The mining sector has been subjected to numerous litigations in the past few years. Important judgments related to mining sector have been pronounced by the Supreme Court. Besides judgments on the issue of allocation of natural resources which have a direct relevance to the grant of mineral concessions. Kindly note, underline that. Allocation of natural resources which have a direct relevance to the grant of...
From paragraph 4.
Paragraph 3 I was reading. I'm so sorry. I'm so sorry. May I read paragraph 3 again? The mining sector has been subjected to numerous litigations in the past few years. Important judgments related to the mining sector have been pronounced by the Supreme Court. Besides judgments on the issue of allocation of natural resources which have a direct relevance to the grant of mineral concessions. Mineral concession is mining leases. Let me read the next one. The present legal framework of the MMDR Act 57 does not permit the auctioning of mineral concessions. Auctioning of mineral concessions would improve transparency in allocation. Government would also get an increased share of the value of mineral resources. Therefore, 15 said that auction is the rule. Some applications where some kind of progress has been made, we will protect for 2 years. Thereafter, everything will go to auction. Kindly see paragraph 5, my lord. In view of the urgent need to address these problems, the MMDR Act 2015 was promulgated on 12th of January 2015. The present bill is to replace the ordinance. This bill is designed to put in place a mechanism for what, my lord? Eliminating discretion, improving transparency, simplifying procedures, eliminating delay, obtaining for the government. 5, very important. Obtaining for the government enhanced share of the value of mineral resources in the country. So one of the thrust was that this government should earn more money.
Yes.
Your Lordship may now see page 9. This 15 was further amended on 10th of March 2021. So 15th brought in a regime of auction. It gave a window to some kind of pending applications for a period of 2 years. And now in 2021, 15 was sought to be amended.
Yes.
Now kindly see, my lord, it starts at page 9. If my lords are kindly pleased, my lords, to go to page 10. My lords are page 10, my lords.
Yes.
Kindly see paragraph 4. The mines and minerals Development Regulation Amendment Bill 2021 provides for the following. And my lords may kindly come to the foot of the page where it is Roman 6. My lords, have it minutes. May I read it slowly. To close the pending cases of non-auction concession holders which have not resulted in granting a mining lease, despite passage of considerable time of more than 5 years, the existence of these cases is so and so and antagonistic to the auction regime. The closure of pending cases would facilitate the government to put to auction large number of mineral blocks in the interest of the nation, resulting in early operationalization of such blocks and additional revenue to the state.
Okay.
And that is why, my lords, that 10A-D, your lordships came, it came after the 21 amendment. So this is 10th of March 2021. Your lordships will get it at page 11.
Yes.
Now, my lord, page 12 is the first judgment. 1973 1 SCC 584, State of Assam versus Om Prakash Mehta, my lords. And your lordships will kindly only see one paragraph. I will not trouble your lordships, my lords. Paragraph 12 at page 17 of the compilation.
Yes.
Your lordship may see, my lord, page paragraph 12 at the foot of the page. At page 17 of the compilation.
Yes, got it. Yes.
The acts and the rules thus contain the complete code in respect of the grant and renewal of prospecting license, as well as mining leases in lands belonging to the government, as well as lands belonging to the private person. The main point to be kept in mind is the fact that mining lease in question is in a land belonging to the government, and it is for the minerals included in the first schedule of the act, in respect of which no mining lease can be granted without the previous approval of the central government. Normally, the government, like any other owner of the property, is entitled to choose with whom it shall deal and what sort of a contract it will enter into. But being a public authority, it acts as necessarily to be regulated by certain rules. The Act and rules in this case are intended to regulate the development of mines and minerals under the control of union and contain provisions necessary for that purpose. Now, next line is very important. No person can claim any right in any land belonging to the government or in any mines in any land belonging to the government, except under and in accordance with the Act and the rules, or any right except those created and conferred under the Act. There is no question of any fundamental right in any person to claim that he should be granted any lease or prospecting license or mining lease in any land belonging to the government. It is necessary to bear this in mind because some sort of vague right was claimed on behalf of the respondents, as though there is a right of renewal, that is the case of renewal. So they say, my lord, everything has to be regulated in terms of the Act and the rules. And there is one provision under the MMDR Act, Lord, section 20, which says that any lease granted in violation of the Act and the rules is void. I'm sorry, Lord, it is not. Lord, section 19. Your Lordship may only note it, Lord. I will not trouble with your Lordship with that. 19 says that if any lease is granted in contravention of the Act, then it is void and it will have no effect. Your Lordship may only note that. The next judgment, my Lord, page 21, 2010, 13 SCC, page 1. This is page 21 of the compilation. Paragraph 57. Paragraph 57. Yes. My Lord, page 57, paragraph 83. Paragraph 83, my Lord, issue G. Paragraph 83 at page 57. But here what happened was certain recommendations had been made in favor of Jindal and Kalyani, which was cancelled. Now the argument was, my lords, that under equity we are entitled to relief. And paragraph 83, my lords have paragraph 83, my lord, page 57 of the compilation.
Yes.
My lord, the Chief Justice has it.
Yes, yes.
Yes. The law of equity cannot save the recommendations in favor of Jindal and Kalyani because it is well settled principle that equity stands excluded when a matter is governed by the statute.
Yes.
My lord, the next judgment, if your lordships kindly sees, my lords, is Monet Ispat, which is at page 62 of the compilation. But I will not trouble your lordships with the whole judgment.
Yes.
Para 192.
Para 192.
At page 110, my lords.
Yes.
It's at page 110. My lords have it, my lord. My lord, I will read actually para 194, page 111, classitum G at the bottom of the page. My lords have it, my lords. Page 111, last 5-6 lines, in my opinion.
Yes.
My lord, promissory estoppel was invoked, and they answer it like this. In my opinion, the state government cannot be held to be bound by its commitments or assurances or representations made in the MOU. My lord, what had happened was there was a MOU earlier. So they said now under the MOU recommended. By enforcement of such commitments or assurances or representations, the objects sought to be achieved by reservation of such subject area is likely to be defeated and thereby affecting public interest. My lord, in case your lordship take this, you did not do it by 2 years. Now 10A2D has come and the auction is the regime which will be in public interest. The overriding public interest also persuades me in not invoking the doctrine of promissory estoppel and legitimate expectation. For the selfsame reasons, none of the appellants are entitled to any relief. Now, my lord, the next judgment. If your lordships now kindly come to page 177. Page 177. It is AP Christian Medical College, page 177.
Yes.
This is that famous case, my lord.
You are referring to paragraph?
I will refer to paragraph, my lords, in just a second. Page 188. My lord, sir, page 188, para 10.
188.
My lord.
Yes.
My lord, what is the prayer in the writ petition? Direct the state government to grant us a lease under 10A2C. My lord, your lordship saw, my lords. that 5-1 approval is under reconsideration. Assuming it is not there, even then you don't have a mining plan, but the mining plan is for captive. Now 1910-2D has come. The 2 years period has elapsed. So now there is a mandamus. The prayer is issue a mandamus.
Existing rights has to issue, that's all.
Yes. So what they say, my lords, any direction, 10th line from the top, any direction of the nature, my lord, just see, kindly see, my lords.
Page
188, paragraph 10.
Page 188.
188 of that compilation.
Yes.
My lord, 10th line, about 10 lines from the top, my lord, any direction. Let me read the whole thing. Mr. K.K. Venugopal, Learned Counsel for the students who have been admitted to the MBBS course of this institution, pleaded that if the interest of the student should not be sacrificed because of the conduct or folly of the management, and that they should be permitted to appear at the university exam, notwithstanding the circumstances that the permission affiliation had not been granted to the institution. He invited our attention to the circumstance that students of the medical college established by so-and-so were permitted to appear at the examination, notwithstanding the fact that affiliation had not been granted by the university. See, Venugopal suggests that we might issue appropriate directions to the university to protect the interest of the students. Your Lordships have that line, but next line. We do not think that we can possibly accede to the request made by Sri Venugopal on behalf of the students. Any direction of the nature sought by Sri Venugopal would be a clear transgression of the provisions of the University Act and the regulations of the university. We cannot by our fate direct the university to disobey the statute to which it owes its existence and the regulations made by the university itself. We cannot imagine anything more destructive of the rule of law than a direction by this court to disobey the laws. My lord,
Yes.
in conclusion, therefore, my lord, I will give a written note, your lordship, never write anything. My submission is that under section 10 capital A, all applications stood lapsed. Two kinds of applications under 10A2B, which we are not concerned, and a 10A2C were saved for 2 years. In the meantime, they come to your lordship's court, and there was some interim order. In the meanwhile, 10A2D has come. Now, admittedly, the approval, 5-1 approval, which is the basis of their case, that is under reconsideration. Assuming it is not under reconsideration, even then they don't have a mining plan. They did not have a mining plan by 2017, 15th of January 2017, under which it can be granted. And my lord, overriding public interest, your lordships have seen auction versus grant. And therefore, my humble submission, Lord, the writ petition is devoid of merit, liable to be dismissed, my lord. I am grateful to your lordships for a very patient here.
Yes, Mr. Jain, do you have to say? Time is running out of our hand.
May I make a quick attempt?
I think you have made 3 points to be responded by you.
Yes.
Number 1, that after introduction of 10AC, that the time has been prescribed 2 years. And during 2 years, it did not cure your petition. And second, thereafter, when the section 10AC came into operation, your application lapsed and they have all right to go for the auction.
Correct.
That's 2. And third is the overriding public interest.
Yes. But fortunately, and therefore I'm grateful my lords pointed this out. On 12th September 2023, the Supreme Court has pronounced a judgment. Just as well we started on 24th July. This has come on a lighter note as an intervening or a supervening event. And my lord, similar rejections upheld by the High Court have been reversed. And I'll just articulate the point in 3 sentences and I'll show that judgment. And I'll pick up from where my learned friend left. If my lords noticed all the judgments given by the state, kindly see the vintage. None of them are applicable. The Supreme Court expressly in this judgment of September 2023 says you only have to look at the amendments and go by it. Holds the right to be intact. And a very similar case I'm going to show. So please take it from me, just in the interest of time, that this judgment completely, my lord, now holds the field, talks about a similar situation of 5-1, etc. And my lord gives a direction to the state government to execute the lease. So this is of 2023 vintage. They expressly note Bhushan, which also, my lord, recognize the 3 categories and says Sandur can't undo. That's why I'm pointing out all of them were of a bygone era. None of them are relevant. My lords would also recollect, and I will show that very quickly, my lord, this entire storyline which has been scripted is contrary to the record because the very government, not once, but on 2 occasions, asked the central government about the special conditions. They stood rejected twice, not once.
Yes.
They never challenged it. My learned friend tried to say, oh, I wrote a letter of January 17, which we didn't challenge, not mentioning that we had a 6th January. Prior to that, we filed a writ petition and we are protected by an order of this court on 9th. So, my lord, it is all, if I may put it, much water has flown under the bridge. And since my lords have been gracious enough to give me a few minutes, I'm just bulletizing these answers. It's as simple as this. Just give me 2 more minutes. So, my lord, if I may use the word, the concocted storyline is contrary to the record because their own requests on multiple occasions to the central government asking for relaxation under 27 stood rejected. They never challenged it. So those conditions, if I may say so, come to an end automatically. Number 1. So all this is of no use. Second, my lord, the sunset period is 2 years, comes in January 2017. Many of the letters referred to, including 21st January 2017, are all after that. So those letters also, my lord, with great respect, do not come to the aid of the respondent. So all the conditions under 5-1 have been met. And the Supreme Court, fortunately for me, hand it over, says all that was required was a formal lease had to be executed, which is what they have not done, which is exactly my case. So between this judgment and Bhushan, they settled the law. Expressly in this case, they direct the government to execute the lease. And all this, which my lords have heard, my lord, with great respect, does not in any way affect 5-1. 5-1 is intact, my right is intact, and therefore 10A2D doesn't come. And just 1 second before I show, 10A2C exceeds except where the rights have lapsed. So my right is intact and protected. So, my lord, it doesn't come in. So, I'm only showing that.
No, that to a specific query I just put to Mr. Korija. He says that it has lapsed despite all these things.
No, it can't. I'll just show.
And he has also just made a statement and shown his decision that whatever way the law will take its course, not the representations of the letters can stop the operation of the law. That was the exact reply Mr. Korija made.
Yes. And therefore, that's why I said I'm answering by nothing better than the law declared by the Supreme Court, reiterating the law passed by Parliament. Now, my lord, quickly, may I just, with my lord's kind permission, request my lords straight away to come to page 26 for a minute. My lord, this is in the interest of time.
Yes. Paragraph 14.
Yes. And just for completeness, my lords will just note only separately in para 2.3, the mining lease was rejected.
Para
2.3. This is just because when I show the relief here, I'm again, if I may say on a lighter note, knowing that October is not round the corner, they have made it easier by declaring the law. Now, my lord, please have 2.3. Last 2 lines at page 3. Application of so-and-so was rejected. My lord notes that. Then, my lord, at page 19, para 8, Bhushan is noted. My lord sees that.
Page 19.
My lord, page 19, para 8, notices Bhushan. This is only for ticking. I'm just leading up to the punchline. I just thought your lordship should know why in my respectful submission, it covers the entire canvas. Right, my lord?
Yes.
Then, para 10 at page 20 talks about inaction and non-compliance, similar to what we are saying. Then, my lord, they notice Sandur at page 21 and says it cannot undo the direction given because all of these are of an earlier period. No trouble.
No, up to paragraph 9, you have referred to paragraph 10.
Yes. That is just to show similar case of inaction and delay by the government. Similar. I'm just giving the flavor, my lord, to show that it's very similar. Then, my lord, your lordship will have page 23, para 12. They deal with Bhushan extensively, which is the case I had relied on, my lord. And at page 24, they say that the right remains. Sorry.
The replication remains protected.
Yes, exactly. Keyword protected. Right? I'm so deeply grateful. Now let's have para 14, page 26. Lord, in case I'm a little too fast, lordship has stopped me. I'm just trying to ensure that I try and stick to my promise of finishing quickly. Para 14, page 26. The object and purpose of the 2005 amendment is to ensure that allocation of mineral resources is through auctioning. Right now, this is the burden of that song, if I may put it. Now, please have the next page. These exceptions or the saving clauses applies to 3 kinds of situations submitted in 10A2. Right, my lord? Then they say, kindly just, we'll leave some of this, my lord, about middle of the page. The reason for protecting, my lord has that. The reason for protecting this class of cases is on account of the fact they altered their position by spending money on operations of prospecting. Accordingly, the principle of legitimate expectation is applied. The third category is where the central government had already communicated its previous approval or state had issued LOI for grant of mining lease before coming into force of the amendment. Now, kindly note, these are crucial words. The raison d'etre observed is that certain rights had accrued to these applicants inasmuch as all necessary procedures and formalities had been complied with. Now, my lord, note the clincher. I'm using the word now in my favor.
Only formal release.
Only formal lease remains to be executed. Exactly the case here. You can go, my lord, Mahabharata, Ramayana, all over the world.
He has pointed out that despite letters written to you, the 2 conditions were not actually.
But they were all honest. I'm going to show. I just thought, let me
come to that fact.
Yes. So this is formal. Then, my lord, your lordship will have page 26.
No, here I find the 2 analogies of advanced pages of him.
Yes.
One, that these are altering the position to bring the commissary struggle. Others is that these certain rights are accrued.
Please, exactly. So these are the two touchstones, if I may put it, right, that we have to show. Just, my lord, if my lord.
First, I have not understood. What is the altering the position here?
No, altering the position means we have made.
Principle will not apply.
No, my lord, I'm reading the judgment in complete.
Even I don't understand what certain rights that in your favor.
Yes. What
has to get a fair consideration.
My lord, what the Supreme Court seems to have said, flowing from the categories. Yes. And that's what Bhushan dealt with, and I'll just show it to my lords in a minute. Yes. It shows why have we saved? Why is there a saving provision on 3 enumerated categories? It protects them from ineligibility. The reason is you have reached the end of the race. You have won only.
I am not putting this question. I am just trying to understand the law decided by the Supreme Court.
Yes. So, my lord, the flavor is, as my lord always knows, the principle of accrued rights has weighed with the court. And according to the court, that's my respectful submission from what I make out. And it's similar to what we have canvassed before, my lords. everything is happened. If I'm using the word boxes are all ticked.
Yes.
All that remained was a formal execution of the lease. So the Supreme Court says that this category stands protected from ineligibility because they have acted on the basis. We're not carrying out these operations. In this case, broadly 500 crores, etc., has already been invested. But I am putting it on a very simple point that with 5-1 in place, conditions fulfilled, only a formal grant had to happen. That's the point, my lord, I'm citing for my lord's kind consideration. And if my lord now kindly just has 36 and 37. Para 20, last 4 lines. There should be no difficulty in granting of mining lease to Messrs. So and so. Now, my lord, please have para 21.
Yes.
Kindly come to the bottom. May I read, my lord?
Yes.
The amendments made by the 2015 Act were not the subject matter of decision in the said case. So all the cases cited and would have to be considered by the courts and authorities as a judgment's binding ratio depends on the legal provisions considered, interpreted and applied in a given judgment. Now, please have the next line. When the law changes by an amendment in the legislation, the amended legal provisions have to be considered, interpreted and applied. So none of the judgments relied on, as my lord saw, have any bearing. And hence the court says we allow the appeal with the direction that the government executes a mining lease. That's exactly the prayer which I have canvassed for my lord's kind consideration. Now, my lord, very quickly, if my lords could just have from the compilation I had given Bhushan for a minute. Page 16 of my compilation, para 22.4 is direct.
Yes.
Compilation of.
So this is in a compilation I had given?
Yes, yes. This is Bhushan.
Yes, ma'am. Lord, I placed para 17 as well for my lord's kind consideration, but again, in the interest of time, I am drawing my lord's attention straight away to page 16, para 22.3.
Yes.
The third category is that category of applicants where the central government had already communicated previous approval under 5.1 for grant of a mining lease, or the state had issued a LOI for grant of the mining lease before coming into force of the amendment. Here again, it is certain rights had accrued to this application as all the necessary procedures and formalities were complied with under the unamended provisions, and only formal lease deed remains to be executed. It would thus be seen that in all these 3 cases, some right in law came to be vested in these categories, which led Parliament to make such a provision, saving those rights, and understandably so. So it has put the imprimatur and seal of the court on the legislative intent of saving. Right, my lord? So that's the foundation and bulwark of my case. Now, my lord, kindly have the paper book for a minute. Page 45.
Page 87.
Yes.
Lord, I'm just going to use this page and make all my submissions so it's convenient for my lords, my lord, apropos the queries which my lord has put to me and my response with my lord's permission. So, my lord, this is the 5.1 central government approval which my lords have seen multiple times. Just make a note in para 2, it says that before the mining lease, the state government will ensure compliance with the amended provisions of the Act and the rules and applicable acts, including forest conservation and environmental notification as issued. Just note here 3 dates, my lord. EC, FC and mining plan all were granted. Page 108, 293 and 81. So all of that in our respectful submission done. Now, my lord, come straight to my learned friend's point. Sorry.
Yes.
Should I give the date and page again for my lord's convenience?
Yes, yes.
Yes. My lord, the EC is 16/5/2007 at page 108.
Yes.
One section. Then, my lord, FC is 20th December 96 to 93.
FC is 20th December.
My lord, 20th December 2016, page 293. Lord, it's also at page 384, but what I'm doing, I'm trying to distill everything on this one page so that it may be more convenient for my lord. So, and 87 is the mine plan, 24th March 2005. So we pause for a minute. My principal point for my lord's kind consideration.
Mining plan is 24th March
2005.
2005.
Right. 87. So now, my lord, in my respectful submission, this fully satisfies this provision. Now let me try and straight away show my lord 3 pages. My lord, the state government on 27/9/2004, my lords have seen it multiple times at page 52, says accept the terms and conditions and sends a pro forma saying you must sign it by 25/10/2004. So deadline, pro forma, sign. This is 27/9/2004, page 52, my lords have seen. Fortunately for us, my lord, much of what has been argued goes and flies in the face of their own full condition too at page 55 after those 12 to 17, which says the conditions in 12 to 17 are subject to the approval of Government of India under 27(3). This will spring to life, that is 12 to 17, only upon the central government approval under 27(3). So if I may use the word, it is dormant.
This is the 12th February 2017.
This is 27/9/04.
No,
Page 52.
no, I'm page 55. I'm talking.
Yes, my lord. Yes. Right? So
What is the date?
yes, 27/9/04. Your lordship will see under the signature of the joint secretary, it says 27/9/04.
Okay.
I'll of course give a note also, but right now I'm beating the clock. So, my lord, he says, accept format, put your thumb impression, and before 25/10, failing which you do not accept the condition. Right? But reading the document as a whole, he himself has said all these conditions are subject to 27(3). So they are, if I may use the word, dormant and inactive, will only spring to life when the central government gives its approval under 27(3). Right, my lord? Now, immediately, without much ado, if my lord kindly has page 58. 58. Yes.
There is a 4/7 letter.
Yes, my lord. I'm so grateful. My lord, kindly see the second para straight away. I am directed to refer to your letter which my lord saw on the subject and to say that the proposal for imposition of special condition has not been agreed to. So first point straight away, clause 2 of the state government's letter saying I want to impose 12 to 17 stands rejected, they fall, dead, perished. Story doesn't end there. They make a second attempt at page 58, 59. It's rejected at 61.
59, 60 second attempt. 61 is the second rejection.
So, my lord, at 59, the government makes a second attempt.
For imposing the same clause.
Yes. So it's like, my lord, in a test match, you have 2 innings. They're playing the second innings. I thought it was a one-day match, should have been only one. But anyway, let's accept the test. At 60 at the bottom, my lords will note, he says, it is requested again that the proposal of the state government for imposition of special conditions dated 27/9/04, my lord, again reiterating the same thing, returned back by so and so may be reconsidered and imposition be accepted. Now have 61, para 2. The state government has proposed to impose conditions in order to ensure that iron ore reserves of the state is gainfully utilized for maximum value addition inside the state. The central government is, however, of the view that making mining is an independent activity and any downstream industry is a commercial decision of the lessee. Kindly note, as such, the central government is not in favor of imposing the conditions proposed by the state government. Recommendation. Right, Manoj?
Yes.
So clause 2
121.
has been rejected. Story over. Everything else which has been argued in my respectful submission has no bearing in law. It is psychological satisfaction that you were chasing me round the park. And my lord also said public interest. My lord, at page 122, in their own meeting of the screening committee, which had the director of mines and every senior officer from the world of mines and geology, at 122.
Yes.
But somewhere in the middle, it says in view.
I know. We have noted this part earlier also.
Yeah. Oh no, I'm not putting the minutes in issue. I'm showing a finding of fact, if I may say so, which says in view of the above compliance and taking into consideration the applicant has established an industry inside the state contributing to the growth of the economy of the state. I'm not, please note, my lord, I'm not referring to the recommendation which he will say the state did not accept. I'm saying a high-powered batch of officers of the state, all from mines. That's the key point. And they were looking at, my lord, the matter in substance. Say this value addition, it's in the interest of the state. So, great respect, state cannot act contrary to its own findings or noting in the very least of the high-powered officers drawn, my lord, from this very department who are concerned with this.
Before the first rejection from central government.
Yes.
So this is.
Yes.
And, my lord, my learned friend referred to the condition in the mining plan. Similar condition, your lordship will only make a note that was prior to the rejection. 24/3/05 was the date of the mining plan, and the rejection that I've showed my lords was 4 July. So all of them perish and fall. That's the point I'm making. The common thread which flows through all this is all of that perish, they're dead, they're inactive, or using that word, my lord, inoperative. So there's no gainsay on relying on that. My lord, may I do this? I think address the queries. Rest, I'll give a written note for my lord's kind convenience. So, sorry?
I think the written note is ready. Just give the printout today.
Written note.
Yes, correct. Just to deal with whatever, if it meets with my lord's approval. If it meets with my lord's approval, I've already given a note. But if it meets with my lord's approval, just what he's dealt with today, what I've argued, if it benefits the court, I can just reduce it in 2 or 3 pages.
That should be convenient.
Yes, I'll do that. Judgments I have cited, I'll put this recent Supreme Court judgment in that binder. And therefore, my lord, I've also showed that 10A2D doesn't apply because if you're protected and safe, that doesn't come in. So my whole story happened within that period. And hence the prayer, my lord, similar to what the Supreme Court has granted in that matter. I'm appealing to my lords, my lord, to kindly do so. And one other thing, my lord, this court had passed interim orders way back in January 2017, lord, and your lordships have expressly protected us at as far back as in the order compilation, if my lords kindly has 9/1/2017. My lord has the order. Lord 9/1/17.
Order number 9/1.
Yes, this is order number 2.
Yes.
The last para suffice for today. It is further provided that keeping in view the order of the apex court in the MESCO case, it is made clear that under these circumstances, the cutoff date of 11/1 will not come in the way of granting relief to the petitioners if it becomes necessary. So, they're trying to cut me off, but the court has expressly said you can't be cut off because everything that I've done is before 11/1/17. And my colleague instructs me to say, which I already said earlier, but just that every correspondence they showed is past that period, past the cutoff date. So that has no bearing. So his whole reconsideration point comes beyond the cutoff date. It has no legal significance or consequence. And that again, as I said, re-emphasizing my point, is a misplaced attempt on the part of the respondent to defeat accrued and settled rights, which as recently as 12/9/2023, Supreme Court has reiterated following Bhushan. I'm so grateful, my lord.
I'll just deal with this judgment for 2 minutes. So this was not cited on the last occasion.
Because it came on 12/9. This was my first time I could
So in
cite.
all fairness, my lord, instead of talking about Ramayana and Mahabharata, my learned friend would have been truthful to your lordships. Would your lordship see para 2.8?
2.8.
Yes, yes. This helps the state, and I will satisfy your lordships in a minute. Page 9, 2.8. I won't take much time, my lords.
No.
Yes.
It's all right.
Your lordships will only note, my lords, for the middle of the page, the lease that was being considered is 76 acres. My lords have it. I will not trouble with the whole paragraph. Your lordships will only note, my lord, they were dealing with a case of 76 hectares. My lords have it.
2.8.
2.8, page 9. My lord, direction was issued towards the middle of the page by the High Court for grant of a lease for 76 acres. Your lordships have that area. Now let us see, my lords. Kindly now turn to page Arun, quick, yeah. Now kindly see, my lords, paragraph. Kindly come to page 26, para 14. So after Bhushan, what they say is, my lords, are para 14, page 26.
Yes.
And if your lordship sees page 27, last 4-5 lines.
Yes.
The third category is where the central government has already communicated the previous approval, had issued a letter of intent coming into force of so-and-so, observe that certain rights had accrued to these applicants in as much as all the necessary procedures and formalities have been completed. So the precedent is their procedures and formalities have been done. Here they don't have a mining plan. They are saying that mining plan is old. If it has gone, it has gone. No mining plan is okay. But am I clear, lords? You will have all this if all the procedures and formalities are completed. And I will show you lordships what they did in this case. Now, if your lordships kindly turns to para 16, page 30. Just like our case. My lords, sir, page 30, para 16. Page 30, para 16.
Yes.
Kindly see, my lord, last 4 lines of the first paragraph. Therefore, in our opinion, my lordships have it. Therefore, in our opinion, para 16. Grant order dated so-and-so is provisional and is subject to fulfillment of the conditions therein. This is clear from the terms of the grant order dated 16/7/2015. So they lay down, my lord, so many conditions. And if my lordship sees the next page, one of the condition is paragraph IE. Yes. You shall have to submit consent letters of owners of the land under consideration before execution of the lease deed. Consent of rights or a condition to that effect should be incorporated in the draft deed. Just kindly note this. Now your lordship may kindly see, Milaj.
Yes.
Page 34, para 19. My lords have it.
Yes.
Further, whether consent letters of the owners of the land in question royals obtained by the respondent number 1, Mr. So-and-so still hold good would be relevant as there could be a change of hands on account of transfer, inheritance, etc. connected with these are legal issues. First, whether the respondent number 1 industry has altered its position post the issue of grant order dated so-and-so, but before enforcement of the concession rules 2016 to get the benefit of rule 61 of the concession rule 2016. It is necessary to ascertain the facts and then alone one can adjudicate and decide the questions whether the respondent number 1 so-and-so is entitled to provision benefit of proviso to so-and-so. This has not been verified, ascertained, and issue arise on whether the application filed by the respondent so-and-so way back to 98 would still hold good at the time when the application was filed. Approval of central government is required. So what they did, my lords, if your lordships kindly turn over the page, out of 67 they gave only 20. They said for 20 there was no condition because it was government land. In all fairness, the petitioner should have told your lordships that it is not 67 but 20 even. And why 20? 20 was government land. No certificate was necessary. Am I clear, my lords?
Yes.
So here, admittedly, my lords, there were terms and conditions. And today they are saying 1 and 2 is gone. What happened to 3 and 4? What happened to your letter in 16 to the government of India?
In the present case, whether they are the private land also involved.
In our case, this is not private land. In our case, there is no private land. But in our case, what here they said for 67 acres is the toll case. 76. 40, except 20, the rest of what was private land. One of the conditions of lease was that you must get these clearances. They said you have not got the clearances, therefore you can't get. In my case, I have given them terms and conditions. They have accepted it. To say you put a thumb is not a case of a lion and a lamb. You are a big industry. You don't put your thumb. And let us assume you have put the thumb. Kindly see the letter, his own letter, after the 2015 amendment, writing to the government of India, please grant a captive clause. Was it there? If it was there by that way, what is his whole argument? Whole argument is that your request for a captive clause has been rejected. It can't be opened. Forget my letters. Let us see your letter at page 77. Some Mahabharata and Ramayana must be told to your lordships. When we are dealing with thousands of crores. Just see page 77, 17th December 2016. After all Ramayana and Mahabharata, after the 2 rejections, page 77, annexure 12. It's public money. I will stop, my lord. Just these 2 lines and I'm done. Kindly see page 77, annexure 12.
Yes.
My lord, I see the letter of the date of the letter, 17th December 2016, post amendment, and kindly look at the foot of the letter, my lord. Who is saying this? Not the state government. It will dead and dusted. History gone. What is the letter? Secretary, Ministry of Mines, Government of India, with a request to kindly look into the matter and facilitate us in executing the mining lease with the Government of Orissa as we are going to accept the condition of captive use clause with the state government. By that time, all these 2 rejections were gone. My request, it has been revived. But you don't contest that. Why should I challenge? You yourself are saying in 2016 to the government of India, please give a captive clause, I will release it. That's all, my lord. I will also file a 2-page. Grateful to you. And if they say mining plan is not there, then there is no lease.
No, they on the contrary, they say the mining plan was there.
They said that the clause condition in the mining plan regarding captive is gone after those 2 rejections. So therefore, they have to have a new mining plan. If that is gone, then we have to have a new mining plan. Anyway, my lord, we'll get grateful to your lordship. We'll file a 2-page notice.
Test of severability. Only that falls which was not granted. And I had, your lordship had put this question to me when I had opened also, and I have instructions and we can file a further affidavit that we are committed to captive in the state is our consistent position, unequivocal position, reiterated in our communications in the writ petition, and I can file a...
I'll be more than happy, my lord, to agree to auction condition. Let the state get some revenue from these areas.
We are very deeply grateful, my lord, for a very patient hearing.
Today itself, you please give them.
We'll try and give it by tomorrow.
But by tomorrow, can we give? That's convenient.
Tomorrow is a holiday, that is the difficulty.
Friday.
We will try and...
No.
Can we
Sir, can we email it? Then we can happen before these 2 days. I see the benefit of doing it later today or something like that.
Anytime today. There is no difficulty.
Well, we'll do.
Just upload it.
Yes, ma'am. Grateful, ma'am. Extremely grateful.
I think just to give you there is a email address.
The lordship directed me to file an objection to the affidavit and just filing it. Near to the instrument 25th, Mr. Mukherjee Leonard Senior is there and serving copy of it on him. Because the document which can be filed by him and disputing the circumstances are highly suspicious. That is why I'm filing the reply.
Go to the month of October.
So just filing that because
the registry because
I have served copy of it. The election may come according to this matter. This is part of the Finnish community lordship.
Can you go to the 6th of October?
My lord, item number 6, which has been fixed at 12:30 today, lordship.
I know that I have served copy. I will be filing it in course of the item number 4.
My lord, sorry, profuse apologies. Last time also, your lordship said an interim order to continue. So till then.
Yes.
So,
My lord,
CAV, so the no order is now required.
but last time also, your lordship said I leave it to
All right.
continuity
is not
purpose.
required. Till the
Continuity purposes for the record, my lord. I'm just saying, this is the original procedure.
All right. Let us see.
Great.
I have served copy and filed in course of the reply to the affidavit.
Pardon, my lord. All right, Mr. Subrat Mishra. Council against the response number 2 and 3 has stated that in terms of our order dated 13/9/23. The affidavit could not be filed. So, but the matter was listed on 6th of October 2023. Meanwhile, the said affidavit shall be filed. The matter is released from court. It's already filed.
I have served copy. My lordship.
One request. My item number that could not be taken off today. So your lordships may kindly call on the next day. It is a part-hard matter.
We have already filed the written note of submission. Short point of submission we have already filed. 25th, lordship may call it after fresh admission. It will be disposed of.
Let us see. All right, keep it up there.
Lordship may
kindly call it after fresh admission, my lord.
Your lordship may kindly pardon me. Item number 8 was mentioned by my learned friend Mr. Sahu Milods in the morning. To be taken up on Friday. It's already over, Milods. I was just only humbly praying, no, subject to your lordship's kind convenience. Can it come at the top of the list so that we can be over, Milods?
No, just mention on that day.
Malas.
Let us see the situation.
Malas.
Only one request, Milods.
but a batch of matters that your lordship have posted to 21st, my lordship. That will be taken up on 21st, your lordship. Fix the time, lords. Only that soft copy of the cases will be given to us, my lords. I have already filed an application before the CPC, my lords.
So, copy of the cases.
Yes, read that. We are the petitioner before the single judge, and we are the respondents, my lords.
Let's go and then make a request. I think they will provide you.
Yes, ma'am. I have already filed an application, my lords.
My lord, item 10 to 25th. May I beg your pardon?
Yes, yes.
Obliged.
My lord, may I have my lord's leave to mention item number 6, lordship, been kind enough to fix at 12:30, could not be taken up. So lordship, at 2 p.m. there is another bench I've seen in the list, lordship, but I'm praying for a interim order, lordship, because their contempt petition has been filed by them and it is disposed of in my absence, lordship, without service of application, without service of any order, even after the order is passed. Lordship,
You go to the Supreme Court, they will recall.
My lord, I am here for
lordship, I beseech lordship.
My objection with my lord to take it up on Thursday or Friday. Any day.
We can bring it back. Or let me get on Thursday. It will come on Thursday.
Lordship, regarding item number 6 in today's list.
21st.
It will be listed on Thursday, 21/9/2023. Okay?
Lordship, grateful lordship. At 12:30, lordship, I believe. Or as is convenient.
That will be mentioned. That day you have to make a mention.
Lordship, grateful lordship. Deeply grateful.
Pardon to make a mention, my lord. Item number 7. This is a PIL matter, my lord, relating to the non-completion of JICA project. And any day your lordship may fix.
It will go to 6th of October. 5th of October. 5th of October. Just bring me soft copies of this hearing matter. Let me read it.
Record, I have served a copy of the limitation petition on the petitioner who is appearing in person. And he is also filing it.
So did we come up to some time?
Lordship may kindly take up this matter next week.
Next week. No, it is first week of October. It will go.
Lordship, there is a contempt petition which has been moved by my lord and friend.
But in the next week, it will be very difficult.
I'm extremely sorry for causing inconvenience to Lordship.
Go to the contempt court, say that we have filed the appeal, it is under consideration.
Since my lord and friend, my lord, agrees to this limitation petition which we have filed because there was few days delay, Lordship may take it up as a fresh admission matter. He agrees, my lord, to that.
You have no objection?
No, my lord.
All right, let the matter, the limitation petition, it just has to.
Is there, my lord?
It is there, okay. They will take up, just wait. Okay.
Case 3, item 7.
Item 7 cannot be taken over 3 p.m.
Call, we cannot fix this matter.
This is a covered matter, revolution appointment matter, this is a covered matter. 6 judgment. RS
And already not disputing all these matters are reality. But 4 to 5 types of cases are there.
Yes. So I will segregate all the cases. Those were covered by my lord's judgment. I will prepare a list to that effect. And some cases those are not covered by my lord's judgment. So those cases are to be segregated.
Okay.
If your lordship will give me 1 to 2 days time so that I have prepared the list. But it's a voluminous matter, so only 3-4 days I want, my lord.
I have 5 matters, and all those 5 matters, there are suppression of facts. Applications have been submitted under the new rules, citing the old rules. They have
some cases. In some cases, they have got appointment under Group D. So they have applied also to.
In that case, we have also dealt with a case under the old rules. They filed an application, and when the new rules came, they also filed another application. In that case, we considered positively in favor of the petition. Case, otherwise there will be some anomalous situation that the old rules applications have filed, you have not considered. Yes. And wherever desperately someone filed under the new rule, we have refused to apply the principle of estoppel there.
In that case, your lordship
already dealt with that. You also already dealt with that in one paragraph.
Your lordship in paragraph 58, 59 and 60 has dealt.
Yes.
But in paragraph 84, your lordship has dealt. Those who have applied prior to that, they will be considered.
Yes, that is what.
Just kindly just listen to him. He may not be against you exactly. Once all of you start saying, so it is difficult to understand also. Yes, please continue. Then you respond. Let him complete, then you respond.
In paragraph 83 and 84, your lordship has dealt that matter and said those who have applied prior to 2020 rule, they will be covered under 90 rules. And your lordship has held if there is the lapses on the part of the state, if there is the lapses on the part of the state. But in some cases, there is a lapses on the part of the respondents. Suppose I am giving an example. One died in 2011. He has applied in 2017. So their lapses is not there. One applied in one case, he has died in 1993. He has applied.
We'll deal with the matter. But what is it? Some cases you have find out, or you are still in screening process. You are still in screening process, or you have done it all?
No, I am in screening process. 1 day. I want 1 day.
1 day means it will go against 21st. It cannot be taken up
on 25th.
22nd. 25th is the Monday, no?
25th Monday. There is no matter after launch.
25th is Monday.
Well, may I suggest one thing? Well, in your lordship judgment, both the issues have been answered. The first issue is which rule will apply, whether the rule which was prevalent at the time of death or the 2020.
No, in this they are not objecting this. They say that another thing, because the Supreme Court decision which have been relied in their judgment, it says the lapse of the state cannot be condoned and the old rule will apply. The same principle
our case stands on a different footing because they applied in due time. They applied in due time.
All right.
So, yes, my lord. By that time, I will segregate all the matters and I will.
Some cases, what happened? My lord, they have applied new, but when the applied and the documents are scrutinized and issued a letter for appointment order, in the meantime, the rule has come along. At that time, they have stated that you file a separate application for that. The agent complaint some the present.
That you have already.
Mine is 5 matter, that is read appeal 808 of 2021. Then 926 of 2021. Then
but Mr. Kuntia on 21st,
I will prepare by 21st and I will submit before my lords by
not before.
And I will
counsel for appearing to the other side, showing that what is your objection in a column.
Yes, ma'am.
If there is an objection, if you agree to show that we agree.
Yes. Last that list, but not completed.
So that's, half of the list I have come.
Or if you want, do not want to disclose what is your stand in one case to the other learned counsel, you prefer in separate pages.
Yes, my 200 pages.
Item number 7.
No, member. Just simply one page member.
Mr. M.K. Kumtiya and Mr. P.Q. Madhuri, the counsel, the evidence.
It's taken by the 10, my lord.
Huh?
Second down.
No, that if you make a similar kind of chart referring to lots of the judgment in the writ appeal already, so that order can be passed.
No, you do not circulate the table showing you the what ground you are objecting to. They will be taken by surprise. Even on that day also no progress can be made.
No, madam, I'll give by 21st.
That is what I'm telling you.
That I'll
indicate what is your
objection. Yes, madam, that I'll put
right.
my learning.
Let the matter be listed and to repeat the instance at 2 p.m.
But it should work next Friday.
Read the column with your date of application.
Objection of the any objection in the context or which the case which covers the present batch of cases cannot be applied.
Date of death and date of application.
Two column will be sufficient.
Sufficient, my lord.
These on that day tell you they are preparing a table, they will supply.
This week they taken the time to time. You will also be suffering. 2000.
Sir, is it in the list today?
Yes.
All passed. What you are saying? You must all
21st.
You'll actually say 22nd, my lord. You'll actually say 22nd. Because 20th is the holiday, so you'll actually say 22nd.
26th, lordship directed for 25th at 2 p.m.
25th matter will be taken up. I will supply that copy by 22nd.
By 22nd,
Page number 34, item number.
Left out methods are there.
Elaborate this matter.
And numbers will be given so that I can verify. Item number 8 and 9. Page 35, item 10.
Item 10, your lordship. Item 10 may be taken up day after tomorrow because the lead matter which has been remitted by the Honorable Supreme Court has been posted to day after tomorrow, the 21st.
I am appearing for the OP number 6, my lords, in this matter. That item is that WPC number is 17691. That is coming on 21st, my lords.
Item 10. Who sent items? 25th, no, they are seeking it 25th.
21st. This item 10, item 10, there are two authorized mentioning which matter. Item 10.
Item 10.
Two matters. And in the past matter, this is the second date after the notice was issued. Well, I have not filed the counter affidavit, and all those matters which my lord friend is referring to, that is ready for final disposal. For let the matter be best. I have filed here counter. I will
give you the opportunity for filing it. Let us see on 25th.
Yes. That is WPC number 17691 of 2015. 17691.
Of 2015,
my lords.
2015, huh? I mean this matter.
Yes, grateful.
Oblige, your lordship.
Glaring. You are finding difficulty with concept of life, then I can do it.
Yes, weekly stress admission item number 1.
May I please initially the petitioner was appointed as assistant teacher. While working as such, my lord, a notification was made for appointment of senior educators. The petitioner successfully come out in the process, my lord. And let's say, kindly have a glance to annexure 3, page number 35, my lords.
Yes.
Well, a list was prepared. May I read it, my lord? The notification dated 11th April 2018 on the recommendation of the Odisha Public Service Commission, the following candidates are appointed in diet cadre. That's me kindly locate is diet cadre mentioned, Group B. In pay scale of level 10, paid by scale to so and so, and their initial basic pay will be fixed at cell number 1. They are posted as senior teacher educator against the existing different diets of the state mentioned against their names. My name is found placed at serial number 14, running place 37 dollars. My lord, it is at running page 78 of the brief, my lord, annexure 16.
So you can refer to the order directly because we are having that copy.
My lords,
The date petition copy is there. You can refer there also.
my lords, the introductory order, am I giving the introductory order, my lords, passed by the honorable court? Issue notice as above, pass set one set of court fee. I will not see the kind of glance.
Where is the rejection order?
Pardon, my lord?
Where is the rejection order?
There is no rejection, my humble submission is.
What you are challenging?
My lord, I am agreed by the introductory order passed by the honorable. Why I am submitting, my lord?
Yes.
The entire garrison list is
The court's query is that yet the order is to be passed.
Where is your assertion in the report that court the pass an interim or interim order?
You see, rather your prayer has been accepted in the interlocutory application and notice has been issued.
My lords. And posting that matter to the November election.
So in November, that after they appear, it will be considered by the court.
But my humble submission is, my lord, by that time my requisition will be infructuous, let's say.
How it will be infructuous?
I will submit, my lord. Let's see the kind of a glance, because no cadre has not yet been fixed by the authorities before committing a person. It is against yourself, my lords.
So if the cadre is not framed,
My lord.
so then you are not in the cadre yourself. So what you are seeking? So what you are seeking directly?
Garrison list is prepared for permission. Where there is no garrison list, my lord, see the kind of a glance by the moment you submit the election put in.
You see, in these kind of matters, the other parties whose you want, they are, freezing of their position or whatever in a garrison list. The court wants to hear them. It is apparent.
But my lord, to allow ownership.
Sir, that is your presumption. The court has to pass that order that garrison list is allowed to run. That is your submission. It is not there in the order.
But since the notice is no state, authorities are going to proceed with the matter.
No, we understand that. We understand that. But what kind of interim order can be passed in such situation? Tell us.
Let's see, for 1 moment, let's see the kind of a glance. Annexure 15, my lord. And the rule I have quoted at, my lords, it is annexure 14, let's see the kind of a glance. The rule, it is the garrison is prepared completely against the rules, my lord. It starts from page number 63, my lord. The relevance question is at page number 66 in the bottom column. That's it, got it, my lord.
Yes.
Recruitment to the post of principals. The post of principals in the diets may be filled up on the ad hoc basis by over promotion from among the senior teacher educators, vice principal on the basis of merit. The selection shall be made by the DPC consisting of secretary education, a chairman, director, TAC, secretary education as members, and concerned joint secretary, deputy secretary as convener. Such appointments shall be regularized subject to confirmation by the Orissa Public Service Commission while giving promotion. Well, this is important. Teaching efficiency, post-performance qualifications, and research works will be given due weightage. After entering 10 years of continuous service, my humble submission is followed. As senior educator or vice principal, he is eligible for consideration for a promotion to the post of principal. So my humble submission is followed. Requests are given to teaching efficiency, past performance and qualification and research works only. But when preparing the graduation list, what the opposite party has done, my lord, they have prepared the graduation list as per the merit list prepared at the time of appointment of teacher educator scholarship. This problem has not been taken into consideration. Second scholarship, kind of advanced scholarship, Annex 15. In the appointment of scholarship seats, they says that it's a guide.
I am not getting, because the provision you have read, it is nothing to do with the gradation list. I'm unfortunate to say this point. It is nothing to do with the gradation list. They have then rightly done according to the merit panel, that is the adopted principle. And this gradation list will be only used for creating the zone of consideration. Then the person's efficiency and suitability will be determined on the basis of this policy that you have just read out.
This is the only policy. I think the government is
not for gradation list. That is what I am observing. How it can be used for the gradation list? These are principles of the one with the qualification and the experience that will be considered. That you are messing up the facts. You are saying the gradation list. A gradation list has been prepared on the basis of the merit panel. It is an accepted principle that when a post is directly recruited, there is no other means except the order of merit that your gradation list will be prepared. So there is no irregularity. If your concern is that I will not be considered in the post of this principal,
my lords,
right? You have to come according to the gradation list within the zone of consideration.
But with due respect, my another humble submission for lordship is when there is no cadre within the promotion as a lordship post does not arise. Your lordship may kindly reverse to Annex 15.
Right.
This is the similar type of employee which I have annexed HRMS ID cards, my lord. You lordship will see from the bottom it is fifth column, cadre.
Yes.
Senior teacher educator of one employee. Next, my lord.
No, come to the rules where you are showing us this call letters. Come to the rule, what rule provides, how the cadre is constituted. Show us that rule.
Well, just now,
these are not the documents that you rely to regarding the formation of the cadre.
Well, they are mentioning different cadres in similar type of categories of employees. That I want to show you for a lordship.
No, it's clear from the senior teacher educator will be the feeder post. Only from them they will appoint.
Then there should be test sub 73 case 73, my lord. Orissa Education Service, the similar employee. Same employee. Case 73. Orissa Education Service.
Asking where is the who can be considered, where is the feeder post? Show us. We do not know. On the basis of your oral statement, we cannot decide a case.
My humble submission is I am annexing all the documents your lordship.
No, where is the rule? Only you have shown this one circular that for the post of principal, these are the things will be considered. What is the cadre formation rule if you are saying the cadre? Cadre is the senior teacher educator. Maybe the other post also, they can be combinedly considered for purpose of the post of principal. Why you show the rule, principal's recruitment rule?
Why Annex 3, my lord, they have declared the cadre direct cadre. They themselves.
Yes.
But in the HRMS ID, none is of teacher education. Somebody is of elementary cadre, somebody is of education service, somebody is of X cadre.
Show us that what is the directive provides for appointment of the principal. If you do not come with the basic rules, it's very difficult for the court to pass any order.
Let's sit next week. Why come with
Your Lord, sir, a moment to see paragraph 9 of his appeal petition.
Petition?
Appeal, my lord. Paragraph 9.
What is there?
He is not objecting the provisional gradation list. Lordship, he has admitted he is not objecting.
And the final gradation list is just repetition of the provisional gradation list. Let's see paragraph, what is the paragraph nine, what he says. Lead name of the applicant was found placed at serial number 17. Though the appellant has no objection to the provisional, the appellant has not filed any objection to that effect. You'll also see that annexure 7 is the provisional gradation list and annexure 9 is the final gradation list.
Is that copy of that?
Yes, but only one is added that perhaps he has been left out in the provisional gradation list and he was placed. You'll also can find his name at serial number 5 of the final gradation list. All the position stands as on the provisional gradation list. You'll also see this man was Devasmita Chakra. You can find in the final gradation list at serial number 18. Serial number 5, Manas Kumar Nayak, he just come to this place at serial number 5. He was not in the provisional gradation list. You'll also see that provisional gradation list as at annexure 7
is
Devasmita Chakra. Her name finds place at serial number 17. So only one change is there. His position is not changed. And he is not disputing that serial number 5 who is in the final gradation list. LSU got it, my page 40, LSU page 48. This is the provisional gradation list. Serial number 17. This is the appellant, sir. And just you'll also see about his Joyce report.
All right.
Then you'll also see the final gradation list as page 54.
I am not disputing that question, let's say. I am not disputing. But can the gradation list be prepared against the rules? May humble submission is. And can the gradation be prepared without cadre? That is the humble submission for, let's say.
He's not disputing the gradation list.
They're not disputing the question of the gradation list because I am challenging the same because no cadre is smaller. As you are is it a cadre? No, we have made representations to central government. Then I can please fix a cadre. No cadre fixed, my cadre is shown as X cadre.
Where is the cadre fixation policy?
No, that I want. So that's why I'm praying for some time.
I can show it because I am reading their resolution. They have created the cadre by this resolution only. Who can be appointed as the teacher educator?
But well, let's say I say let's say the IMSC 15. Each body, everybody's cadre, it is separate. Not should not mention diet category. Group B diet category should not mention. But in my case, they are mentioned as X cadre. In somebody's case, they are mentioned as elementary cadre. Somebody's case is education service cadre.
Yes, they will be, maybe they are posted in different posts and
all in diet. All.
And you are representing all of them.
No, my lords.
You represent yourself only.
My lords.
How you are affected?
Because when without in cadre, no, without the cadre,
you have to be appointed as the senior teacher educator. Are you appointed to that post?
Yes, my lord.
So what more is required for cadre formation?
There must be cadre of similar category of employees group.
Who are you to say this? You applied for that post, you have been recruited, and you are treated as a part of the senior teacher educator.
My lords.
And what else are you want to dictate the government policy?
My lord, they mentioned is appointed as a diet cadre group B. But in HMS idea of my mind cadre has been fixed as X cadre leadership. Not that cadre, they are mentioned.
But that is the dispute you have written. You are raising a dispute regarding the appointment of the principal.
My lords, that is a promotional question, let's say.
Yes.
That is a promotional question.
What is your writ petition? Just show us that you have challenged your appointment in the X cadre post. At what point of time you raised that objection? But Mr. Kuntia says that your name is there in the cadre.
Paragraph 6 of my writ. By this process is no way affected. Suppose what he says someone in the cadre. They are below him. How he is affected?
Where is the cadre?
I am saying that gradation list, if you are making the gradation list, if you are disputing, you are not disputing the gradation list, where is
paragraph 6 of my writ application?
Is the cadre means what? Say that you are appointed in the senior teacher educator, right?
Cadre. They are mentioned.
It is automatically, you are already, if you are regularly appointed,
minors
through the selection process, and you are designated as that post, you are already in the group B cadre. if that post belongs to the group B.
But the mention the cadre is upon a diet cadre. The mention is a diet cadre, let's say. But in my HRM's ID, so we are saying X cadre.
That you challenge there, but you have not challenged.
And in the all the examples are giving before my lord, sub similar categories employees. Which was
come to the writ petition, what is the challenge? Let us see it. Otherwise, you have.
I'm challenging to get us some listed circular, let's say.
And in the writ appeal, you have said you have no objection against the draft gradation list, and final gradation list is the exact replica of that list. So that point you will not allow you to argue. So what is there? Just to see your relief. Shall not be formed. Why? So cause as to why the senior educator cadre shall not be formed, and as to why the final gradation list under Section 9 shall not be quashed, set aside, such and such. There is no grievance that they have treated you as cadre.
But according to my writ application, so let's say.
Just read your relief you have prayed.
There is with due respect, there is other prayer also. Any other directions?
No, that way, this omnibus way, by oral submission in a writ petition, we do not pass any order.
And my humble submission again, let's say, if we have made any provision objection to the provision gradation list, this gradation list cannot be against the rules, against the cadre, against the principle decided.
You have yourself stated in this paragraph 9 of your writ appeal that I have no objection against the interim gradation list. And then and according to Mr. Khuntia, that is just a replica of this draft, this gradation.
Provisional gradation. If they do a final objection, can you override the statutory rule, Mala? My humble submission is the gradation list.
We follow certain procedure in objecting things also. If you say that I have no objection, means you are admitting the position that government has taken. Where is your scope to challenge it again? Tell me, there is a certain principle of objecting also.
My lords.
That you accede to the government gradation list. What is the question of challenging it?
Because it is against the rule. That is my holy submission.
No, that is not allowed to do that. Because you yourself said I have no objection. What is the question of that? I think you better withdraw this writ appeal, otherwise you will fall in a problem. Otherwise, go there and amend your writ petition if you want to have certain dent in the matter. Would you
oblige?
Will you write it?
We'll write it.
File a memo.
My lords.
You are Mr. Akshay Kumar Pandey.
My lords.
Mr. A.K. Pandey and counsel appealing to the petition. And Mr. Pandey has asked for liberty to withdraw the petition. In this regard, he has filed a memorandum seeking leave. Stop. We allow his prayer. The petition is accordingly dismissed as withdrawn. Mr. M.K. Kunti, National Government Advocate, has appeared for the state opposite party, state respondent. All right.
Item number 2. Oblige, ma'am. Item number 2.
My lord, may I please your lordship? Here in item number 2, I pray this may be taken up either on Friday or Monday, but your lordship first.
We will vacate the interim order, Mr. Mishra.
May I just clarify what has happened?
Whatever happened, we'll vacate our interim order if you seek adjournment now.
I can press it today. I'm just pointing out what has happened. Despite your lordship's positive direction, I can place it on merit. I'm not shying away from placing on merit.
Yes.
May I just point out what has transpired in the meanwhile for your lordship's kind consideration? Now, despite your lordship's specific direction that the Raurkela Municipal Corporation should not do any demolition in the meanwhile pending consideration of the appeal, post facto your lordship passed the order and it was brought to the notice of the authorities. Not only they demolished portion in the same evening, on the next day also they completely demolished the building, thereby evicting us. And I have shown to your lordship that it was a suit pending not to evict, and they took help of municipality to demolish the building and indirectly evict us. Now, these facts I want to bring to your lordship notice, the documents I have received today morning, to your lordship notice for consideration, because this is a case where there has been flagrant violation of your lordship direction.
You file a contempt case.
My lord,
You file a contempt proceeding.
I'm filing the contempt, my lord. I'm filing the contempt. Therefore, I was praying, if your lordship brings it along with the contempt, then it will be, my lord, because your lordship, my lord, the concern is with regard to violation of your lordship direction. There are telltale material, your lordship. The telephonic conversation, the sent through WhatsApp and directly served, everything is there, my lord. And there has been a positive direction by your lordship. And this is not the way to override the order of the Honorable
All
Court.
right.
And that is the background why I am praying, my lord.
Anyone who's appearing for Rourkela Municipal Corporation?
No, that day, in fact, your lordship posted it to today for consideration by passing a positive direction, considering the fact that the JCB machines are there to demolish. And now this has...
All right, then we fix the matter on 6th of October. You file the proper affidavit.
No, my lord, I'm only praying for Friday. If your lordship, my lord, permits me, I can place it just now also with your lordship. But unless the contempt, my lord, is filed...
Try to understand the court is having a congested board and every other matter we cannot accommodate.
Your lordship may peruse the order passed by your lordship. Is it the way the municipality should deal with the order?
That is now you file the consequential application that should be brought before us. Otherwise,
I'm filing that, my lord. I'm praying, my lord, your lordship may take up either on Friday or Monday. I'm praying for subject to your lordship.
If they have already demolished, then what will be the consequence? How can you just restitute these buildings? So take time to file it.
Restitution may not be there, but there has to be something which will definitely, my lord, send a signal to them that this is not the way to deal with the Honorable High Court's order. But there has been a positive order. It's not a status quo.
All right. In view of the subsequent event has taken place after the order dated 15/9/2023 was passed, Mr. S.K. Mishra, National Council appearing for the appellant has paid for some accommodation. Questions allowed. Let the matter be listed on 27th September 2023.
Item number 3.
I'm saying, my lord, your lordship may extend the interim order because they are also trying to...
No. In view of your report, what is the meaning of that interim order? That is why I have said this in view of the subsequent event that has taken place here, sir. And you have already reported to us it has been demolished. What is the interim order?
It has been demolished. It has been demolished.
All right. So,
my lord, I'm obliged.
Yes.
Item number 3.
It's in item number 3, as per the Honorable Court's directions, the Learned Counsel for the state was to obtain instructions from the Collector Bhadrak regarding the disposal of the waste.
And it has been removed.
Removed according to their report. You can see it. They are showing it.
I'm also supplying a copy.
You have supply, just see.
Both the photographs in the left side, the previous position. Right side is the removal. Right side, Dr.
Yes. So it apparently shows they have removed the things.
Yes, madam.
All right. You are Mr. Achari.
Shubhankar Das on behalf of Mr. Ramdas Achari, my lord.
Mr. Shubhankar Das, Learned Counsel, appearing on instruction of Mr. Ramdas Achari, Learned Counsel for the petitioner. And we have also heard Mr. M.K. Kuntial and Regional Government Advocate. In terms of our order dated 12th September 2023, Mr. P.K. Muduli, Learned Counsel, has produced before us a copy of the written instruction dated 15 September 2023. Stop. In the said written instruction, the executive officer, Bhadrak Municipality, has categorically stated as follows. It is respectfully submitted that the garbage container, which was installed earlier on the entrance of the Panchamukhi Hanuman temple, has been shifted to outside from the vicinity area of Panchamukhi Hanuman temple, and all garbage nearby the temple has been removed and it is clean. Stop. In support of that contention, a comparative photo series has also been produced before us. Mr. Counsel for the petitioner, having perused the photographs as well as the written instruction as received by Mr. P.K. Modali, has expressed satisfaction. Stop. Accordingly, this public interest litigation is closed. But before parting with the records, we direct Bhadrak Municipality to maintain the clean status of the entrance of the temple. So, a copy of this is received by Mr. P.K. Modali, is taken on record.
Grateful, Your Lordships.
Order.
Copy of the order so that I can communicate to the municipality.
Copy of this order is supplied to Mr. P.K. Modali and counsel for 3. Yes.
Item number 4.
Your Lordship, this is a public interest litigation petition, and I am appearing for the petitioners.
Yes.
The Lordship, the matter relates to inordinate delay in settling the government land in favor of the occupants in Bulla Township, and the occupant are in possession since 1950s, my lord.
Yes.
The background of the case is that my lord, in when the Hirakud Dam has been constructed, vast tract of land were transferred to the control of Dam Authority.
How this can be a public interest litigation?
Litigation, Your Lordship, the petitioner is the convener of Bulla. And
you are talking about the subject matter of the litigation.
Your Lordship, and he is the convener, and the other petitioners are also social activists, and the petitioner number 1 and 2 are advocate by profession, and they have put in their good effort, and they are pursuing the matter relentlessly with the government since 1985. And in the year 89, a decision was taken by the Chief Minister and follow-up action was taken up. But till then, it has not been finalized. They are raising the matter time and again. And it is a common interest is involved because there are so many persons, my lord. And there is inordinate delay in finalizing the settlement plan. The Lordship may kindly see that Annexure 1 of page 31. Here,
how these persons you are representing can claim a right over that land?
The Lordship, they are in occupation since 1950s, and they have acquired their right by way of adverse possession.
Go to the civil court.
Plea of adverse possession is only cognizable by a civil court.
Go to a civil court.
And Your Lordship, they
also look at that circular by the department where it has been said that possession cannot be taken away from government.
Chief Minister. And the matter is taken up by
possession over a land, according to it, is adverse.
It is 70 years, my lord.
And whatever this court cannot decide this issue. Because there is a certain principle you have evidence you have to prove before the court.
Also, the government have already taken a decision in this regard, and the decision is there.
Yes, where is that decision?
Where is that? The Lordship may kindly see Annexure 1, page 31 to 34.
Yes.
Here the meeting was headed by the Chief Minister and the Revenue Minister as well as other officials were present. And the petitioner number 1 was also present. Your Lordship, the decision are at page 33.
Yes.
land would be settled with the encroachers to the extent of 10 decimals in accordance with the provision of OPLE Act. If the concerned encroacher are otherwise eligible for settlement under the provisions of the Act.
Yes.
And thereafter a list of encroacher who are occupying the land from the beginning, that is more than 30 years, will be prepared. I'm coming to the third. Under the provision of the OGLS Act 1962, only house site are allotted in urban area. For this purpose, house site are plotted into different categories. And in number 4, a special additional tahsildar with adequate staff should be posted at Bulla. And secondly, it was decided this procedure should be made applicable to cases of encroachment in Hirakud and Chiplima area, as the nature of the problem is identical. And thereafter, the government in the revenue department, they asked the collector Sambalpur to expedite the matter, my lord. And thereafter,
we all understand it is a process. Where is the? They declare you right that will be automatic. This is
well, lordship,
that resolution date may kindly be seen. Annexure 1.
Now, council, what is the as felt from my lord? What is the process under the OGLS Act? OPLE Act?
OPLE Act, there is.
Can you read that?
Section 7. Section 8.
7.
Section 7. I'm coming to that, my lord.
Section 7.
Section 8A, my lord. Settlement of land in cases of encroachment for more than 30 years.
Yes.
Wherein in the course of any proceeding instituted under section 4, 6, and 7 or 8 against any person unauthorizedly occupying any land, it is proved by such person that has been in actual, continuous, and undisputed occupation of the land for more than 30 years by the date of institution of the proceeding. The tahsildar shall refer the case to the subdivisional officer. On receipt of the reference under subsection 1, the subdivisional officer shall give the department of the state government other than the revenue department to which the land belongs an opportunity to show cause against the settlement of the land and may make such further inquiry as it deems necessary. If after making such inquiry, the subdivisional officer is satisfied that such person has been in such occupation of the land as aforesaid, he may by order settle the land with him, and every such settlement shall be subject to such condition regarding assessment and payment of rent as may be prescribed by rules made under this act. And your lordship, in the decision, they decided to go for settlement plan relying on the relevant provisions.
Also, because para 1 is OPLE, not OGLS.
OPLE and OGLS, and thereafter, my lord.
So they say it may be considered under category in accordance with the government
decided under the OPLE.
So then it is on your part that you have to move under OGLS or OPLE Act, because rather it says that you are encroachers annexure 2 and annexure 1.
Here I have not stated the background of the case. Here the
background, sir. Background is fine. Annexure 2.
Here the magnitude of the case, my lord. It was just an alarming purpose. The level of collector, and moreover, one ex-chief minister,
the collector is in power.
Your lordship, the RDC has directed the collector to prepare
because it is a statute. So kindly refer to that.
Your lordship, it is. I am relying on the order of the RDC.
Kindly read OGLS. Mr. Counsel, the problem is that you are referring to a statute and you are not sticking to that.
I'm calling.
We are talking about RDC collector.
Okay, let's go.
You refer which section of the OGLS Act?
I'm coming to that, my lord.
Just kindly tell the section what you were just now reading there.
Including this one. What section?
Demolition. କୋଉଟା ପଢୁଥିଲେ?
OPL ଟା ପଢୁଥିଲେ
ଓଜିଏଲଏସ୍ କହିକି
OGLS ଟା ଅବିକା ଦେଖୁଛନ୍ତି
ସେତେବେଳେ ଓଜିଏଲଏସ୍ କହିଲେ ତ
ଆଜ୍ଞା ଆଜ୍ଞା
OPL. I was referring to OPL.
Oh,
And your lordship, that is provision 3 of OGLS Act matter, and it is meant for housing site matter, and therefore the authority decided that the provisions of OPL Act as well as OGLS Act are inadequate, and therefore it was suggested to frame a special provision matter. The special provision was also enacted in the case of NSC Raulkela matter.
just one, this come to this rule 16 of this Orissa Prevention of Land Encroachment Manual, these rules 1985, come to that. But we are pointing out that has been categorically provided in the rules. It is a manner of settlement of encroached land, encroached for more than 30 years. You read.
finally is it that? Can you get the book? Upon call OPL 16 dash capital A.
16
15 rules or
16.
I'm coming to that, madam. Manner of settlement of enclosed land under section 7.
Yes.
Before the tahsildar proceedings proceed with the settlement of unauthorizedly occupied land under subsection 2 of section 7 of agriculture or
This is something.
this will publish a
No, just wait. This reads manner of settlement of enclosed land, enclosed for more than 30 years. For settlement of land under section 8A, the owners of proof that the encroacher has been in actual, continuous and undisputed occupation of the land for more than 30 years by the date of institution of the proceeding shall be on the encroacher. If the subdivisional officer orders settlement of the land such and such, he shall fix the rent on the land in such a manner, such and such that the procedure is given. So, whether a writ court in a public interest litigation will decide whether you are in the settlement, there is no dispute regarding your possession, can it be done?
Your lordship, it is under contemplation of the government. Government decided to cover the cases under the OPL Act as well as
only just hear me, just government by that resolution has only initiated a process that they find out these people.
And this resolution is of the year 1989. By that time, Budla was a very small town. During the process, 30 years, it has become a very big town, and these are all commercial areas encroached by them. And there is a necessity of expansion of road.
Here, the background of the case is that the Hirakud Dam was completed, the offices were closed, and the vast tract of land were relinquished to the irrigation and power department, and thereafter the government utilized the land for construction of medical college, as well as, in fact, there is
sorry, these were not private lands. Don't unnecessarily introduce the narrative which is not relevant to the context. No, these are all the government land.
Yes, that is.
If you are abstract from your private land, we understand that may be a subject matter of the public interest litigation. If you do not be given proper compensation, proper settlement, that we understand. This is not your case. Your case is very simple. We are occupying the government land for the last 30 years.
More than
whatever. 30 years comes from this section 112 of the Limitation Act. Also keep in mind, this is not out of the heaven it is brought. It is brought under section 112 of the Limitation Act, the 30 years. So, whether the 30 years, and you know this adversity of possession is a matter of always evidence. Because the two important principles Supreme Court has time and again settled from the date when the possession has become adverse. Because in earlier Limitation Act of 1908, it was a continuance of the possession. Now it has been amended Article 65 of the new limitation act of 1963 says, from the date when the possession has become adverse. So who will prove it? Well, from the date when it was the possession has become adverse. Because continuous possession doesn't give you any right even of consideration. This is only civil court can decide.
That mechanism is only available in civil court to determine all these issues.
Please kindly see page 39
of
the brief. And Annexure 4 series. And here the RDCND also went through the decision taken at the level of Chief Minister. And we are
the court, we are not the advisor of the Chief Minister. Remember this. The government in their wisdom wanted to regularize the encroachment, giving some land not beyond 10 decimal, I think.
Yes, that is 30 years back.
And you'll also it is of in fact the
just tell me what
and it is a continuing cause of action.
What cause of action? Go to the suit.
Till 2016, the matter was under consideration, and the collector.
Where is your right? What is your right? Where is your right? The collector must consider this regularization.
It is a direction from the government.
It is a matter of policy.
It is a direction from the government.
What is the direction from the government? When the statute is just opposite. Statute says
that's why the citizen council they have proposed a law in the light
please go
in the light of a provision.
The Central Department. We do not also act as a post office to send your proposed law to the Assembly. Sorry, this cannot be the subject matter of this public interest litigation.
So, also there is a precedent also in the case of Rahul Kala NAC because the provisions of OPLA as well as OGLS were inadequate. Therefore, a special provision was inserted. I have a copy of that.
You go to the legislative department of the government. You change the amendment. We are not here to amend the law. That is doesn't fall within our portfolio.
And it is under consideration of the government, my lord. They propose it is under consideration.
Holding that book, that chapter is there for Arkala. Now Bhubaneswar has come. You are referring to settlement of enclosed land as per OPL and OGLS. Actually, the long and short of that resolution is that as following OPL or OGLS, they may be settled. So where is your claim? Even you have on your own showing, you have never claimed under OPL or OGLS.
And
you must have marked there are several lead petitions filed by encroachers. They're stating that we are landless, homesteadless, which is defined. So we are entitled for settlement and they are not considering. Then even the writ court is directing the authority under the statute to consider it. And you did not read that. My lord read that it is SDM or whoever is the authority.
And for now, show us who are the persons that are taking over the land. Where is the list of those persons?
That is also not.
Just a minute.
In fact, the RDC asked to prepare a list, my lord.
No. Where is your list with the petition? We have to believe that you really know those persons and for their interest you are coming before the court.
Your lordship, then I have to file an affidavit regarding that. Because bus number, the number is.
You must know. Because the settlement has to be made against individual.
And settlement was also completed. In fact, more than 2,400 acres were acquired. Adjoining areas. And thereafter, the authority transferred it to the irrigation department.
So what is your problem? Where is the right of being in
they are in occupation. They are in occupation. They are part and parcel of Bulla Township, my lord. They are occupying since 1950s, my lord.
Go to the court individually, not in the form of a public interest litigation. Because I am telling you that 30 years means you are claiming adverse possession. You have to prove that you are adversely possessing the government land.
In fact,
government, if they are in their wisdom by bringing a policy like to encroachers as a recorded as the provided tenant in the under them, that is a different issue. We cannot ask the government.
In fact, there is no record of right in Bulla also, even the medical college has no record of right. And some land, 25 acres were transferred to the NSC. The NSC has not yet got the record of right, my lord, not to speak of private
on the
individuals.
lookout of the petition.
Whether the NSC has given the responsibility on you?
No, my lord,
if they have no difficulty, what is your difficulty? Huh? What is your difficulty? I'm telling you.
In fact, we also raised the matter with the government.
Go to the
Propose
government.
policy.
Look at there, not here. All right. You are Mr.
Asif Kumar Mishra, my lord.
Mr. You are not on record.
Your lordship, I have entered appearance. The appearance
Oh.
memo is there. I have a scanned copy of the appearance memo.
Have you filed a Vakalatnama? No, appearance memo is not. Have you filed the Vakalatnama? How can you file the appearance memorandum? How?
Senior advocate, no? Senior advocate, yeah. Hey, everyone. Ragor could happen. Ragor.
The lordship, the
Mr. Ragod is there for the petition.
That on his behalf he can appear.
On his behalf, he can appear.
But he cannot say that I am filing a appearance
You are
memo.
appearing for Ragod, you tell that.
What is your good name, sir?
Asif Kumar Mishra.
Mr. A.K. Mistral on council. Appears on instruction of Mr. Vijay Kumar Ragadal on council for the petitioners. By means of this public interest litigation, petitioner has asked this court for directing the opposite parties, within the state, to settle the land of Burla town with the occupants who have encroached upon the land and occupying the same since more than 50 years with immediate effect after conducting due inquiry in the matter. So it has been further urged that a special statute for settlement of the settlement of the land located in Burla town with the occupants who have occupied the said land by way of encroachment and consequential issuance of a record of right within a time frame as may be fixed by this court. Stop. When he asked the counsel for the petitioner, what is the name as regards the name of the persons who are occupying the land within the area of Burla, he has submitted that no such list is available. Stop. That apart, Mr. Lord Counsel for the petitioner has referred to a minutes of a meeting held
in the chamber of chief minister on 29/12/89.
held in the chamber of the chief minister on 29th September.
December.
29th December 1989, where it has been resolved that the land will be settled with the enclosures to the extent of 10 decimals in accordance with provisions of OPLE Act 1972.
Keeping in view the provisions of master plan of Burla town.
Keeping in view of the master plan of Burla
town.
So a list of approaches who are occupying their land from the beginning for more than 30 years will be prepared in case it is found that they are actually in continuous and undisputed occupation of the land for more than 30 years. Then the question of settlement in their favor will be considered in accordance with Section 8A of the OPLE Act. Stop. It was also decided that adequate staffs will be provided to the Tahsildar to carry out this inquiry. The grievance primarily is that state resolution was not translated into action stuff. The prayer is played in the repetition cannot be entertained by this court for the simple reason that even the decision of the state government has taken in the said meeting does say that only after inquiry, if the requirement is satisfied, the persons will be empaneled for consideration of the settlement. Unless there is an inquiry, the person aggrieved can only approach the civil court for declaring right on prescription, being the prescription stuff. This court cannot be turned into a forum for declaring such right on the basis of encroachment, even if they may be rightfully claim the right of prescription. In terms of the above, we dispose of this writ petition. So the petitioners are given liberty to approach the Secretary Revenue Department for
opposite party number 1.
For opposite party number 1.
My lord, may direct them to approach the collector. Collector will refer it to the secretary.
All right.
That is
to
better.
the collector Burla, no? Yes.
Sambalpur. Opposite party number 4.
Opposite party number. To the collector Sambalpur.
For redressal of their grievance, if any.
The lordship, the competent authority.
Statute. The problem is that you are not referring to the statute, and whenever you are referring to one statute, you are reading another.
Yes.
Just can you see it is very specific. In that 1/10 of acre is there in statute.
That is the following. To the Secretary Revenue Department, opposite party number 1. So it is expected that Secretary Revenue Department, after taking should take the appropriate action if the resolution of the government is taken in the year 1989 is still in force. All right.
The lordship, there is an IA for interim order, my lord.
Always we have disposed your application.
The lordship,
pending interlocutory applications, if any, is
the lordship, there is large scale demolition. And I'm not making a digression, but they are.
These all the civil disputes, we cannot decide, try to understand that. There is no system of taking evidence.
The lordship, and one celebration, Noakhai is to be celebrated day after tomorrow. And there is large scale demolition in Bulla Township, my lord. And
my lord, this is only for expansion of the road. They are all occupying the government land.
The lordship, residential buildings.
You do not know the names of the persons who are going to be arrested.
Councillor was directed by the
RDC. Council, you do not know. Court cannot pass an interim order in the vacuum. You provide us a list, or you can see also for the time being that they should not be disturbed in their occupation. But you don't have any list. Letter ends there. Okay.
My lord, I am appealing for opposite part number 4 and 6. 1 to 4 and 6.
4 and 6. Okay. Next call
item 5.
The lordship, one sentence may kindly be added. The citizen council may be allowed to.
We don't recognize. We ask the citizens council to approach the petitioner. May approach the Secretary Revenue Department. Go there.
Item 5. Item number 5. Before I take your lordships to the impugned order, my lord, passed by the Lord and Single Judge. Lord, this is a matter wherein way back in the year 2016 and 17.
Come straight to your interlocutory application for condonation of delay.
Madam.
That is IA number 6541
Yes.
of 2023, my lord.
Third, BP Triparty Land Council appearing for this is 6541 IA number. Land Council appearing for the applicant, comma, Orissa Public Service Commission. Also heard Mr. What is your good name, sir?
Trilochan Das, in person.
Also heard Mr. Trilochan Das, the opposite party. Number one in person. Stop. This is an application in Section 5 of the Limitation Act for condoning the delay of 13 days according to the stamp report. Stop. Having perused the application, we find the delay took place for administrative decision making. Stop. Even though the said explanation is not satisfactory, but since the opposite party number one has there is no objection, we condone the said delay without issuing any notice to the other opposite parties, as the appeal will only is irrelevant for only opposite party number one. Stop. Accordingly, this application stands allowed and disposed of. The said application since has been it is on record now already, I think. Now come to the admission of the appeal.
That's a this is a case, my lord, wherein the assistant public prosecution examination was conducted way back in the year 2016 and 17. The respondent number one, my lord, he appeared in the written examination. Thereafter, he was called for the viva voce. He appeared in the viva voce. And thereafter, when the results were being declared, he filed a original application before the Odisha Administrative Tribunal.
Yes.
Alleging that there was some question papers which were wrongly set in, the answers were wrongly set. Therefore, he ought to get more marks. And on the basis of that, he also filed a prayer. He filed this application with a prayer that the earlier notification by the Odisha Public Service Commission, which was there in page 103, wherein it was being categorically written that as per the ruling of the Honorable Supreme Court of India, in case of Pramod Kumar Srivastava versus Chairman PSC Patna and others, there shall be no evaluation, rechecking of answer sheets of any examination conducted by the Odisha Public Service Commission. He prayed that notification to be also waived and rechecking to be done. Now, when the matter came before this Honorable Court, my lord, after the
abolition,
my lord, the abolition of the tribunal, Lawrence Single Judge, my lord, on 6/4/95/2023, my lord, has passed an order, my lord. He directed that once again the model answer sheets, which was there, contrary to that, he said, no, you go for setting up another committee and the committee must give the reports. Accordingly, my lord, after going through the reports of the expert committee, he said that the question number 18 and question number 58, he says that there are two mistakes which were there, and court, while disposing of the writ petition, directed the commissioner to award 1 mark each in favor of the petitioner in respect of question number 18 and 15 and reconsider the claim of the petitioner for his selection and appointment. On such reconsideration, if it is found that the petitioner is coming within the cut-off marks so fixed under the UR male category, consequential action will be taken by the commission to recommend the case of the petitioner to the government for his appointment as the assistant public prosecutor pursuant to advertisement of the 2016 and 17. My lord, we had the difficulty, my lord, because way back in the year 2017, we gave appointment to everybody. And in the original application, the petitioner made the last person as a party, but that notice also could not be sufficient because the addresses were not being there.
I am asking you a simple question whether there is any vacancy or not.
My lord, there is assistant public prosecutor, all those appointments are already been over, my lord.
No post.
No post now. For the year 2016 and 17.
How without making and serving them the notice will be going to be affected? Because if you are to be accommodated, someone's appointment has to be cancelled by the court. Court cannot create the vacancy. And you have not made them the party and the person has not also received the notice. The last person.
Because the person who has been made, was made a party, he did not give the address of that person.
That if that was the answer was wrong in 3 questions.
2 questions.
2 questions. Why you will only get the benefit?
No.
The other people who appeared, they also get the benefit.
That direction was given the only single court.
That they shall all will get the benefit.
My lord.
No, my lord. Lords may kindly see the imputed order.
That is the election law.
The appellant advertising 198 post, my lord.
It is only for the petitioner, my lord.
What is that?
Lords may kindly paste to page 112, my lord.
No, man.
Page 112 of the date appeal, my lord.
Para 8, my lord.
Only in favor of the petitioner.
Yes, my lord.
How that can be?
In your position, this court, while disposing which person direct the commission award each man favor of petition respect of question number 8 and 50 reconsider the claim of petition for his selection happen. On such recommended reconsider found that the petition is coming with the cutoff mark. So cutoff mark. Total gradation.
No, where it has been stated that everybody will get it.
No, it is not done.
If it is
not done, it's not done.
Petition will coming with the cutoff mark so fixed in on male category.
That is
no, that is the in respect to the petitioner only.
Total gradation list will be prepared by the direction by the signature that total.
It has not been stated all the persons will be given the same benefit. Why you should only be given that benefit?
Para 7, the appearing in commission order, there come a question of footage are wrongly drafted. All the candidate who took the examination will be entitled to get mark. As per the submission by the OPSC council in the before the single judge, the court directed that the all unreserved category. My lord.
I don't think this. You are a lawyer. That is why I'm asking.
My lord.
Suppose this the person.
My submission having vacancy, my lord. 198 post was my lord.
And we also all right because you are saying that you have made the last person a party. He has not come. Notice was not served. So first of all, we cannot pass any positive mandate that you have to be appointed. Right, and now. Just see, you says that the answers of relating to the question number
18 and 58.
18 and 58 are wrong.
Man.
And you will get for 1 mark each for this question, right?
18 question I have rightly answered, but the OPC,
so question number 8, not 18 question number 18.
Slowly, Sunantu. Don't be anxious. That is your case, we understand. We have all, just Sunantu call culture.
So for each question, you will get 1 mark. Right?
My lord.
Now come to the observation of the learned civil judge. The last candidate in the UR category, you are in the UR category.
My lord.
Has secured 119.625 mark.
My lord.
Right?
My lord.
And you have secured 101.568 marks.
My lord.
If the 2 marks is added,
my lord,
what happens? It becomes a 103.563. Am I correct or wrong?
My lord. I have secured 118.625. 563.
118.
My lord.
No, sir. So that's kindly read. It is my lord is reading the paragraph 6. You are not reading that.
Paragraph 6.
It is written 101.563.
My lord.
Paragraph 6 of the order, internal page 3.
My lord.
Could you find?
My lord.
The petitioner has secured.
My lord.
What is the mark? 101.563 reading. So just exactly that is the yes. And just listen.
And 17 will be added.
17 will be added.
My will see.
Total mark 118.563.
So the question, if you want to get, why not that person will not get 2 marks? The question is also for him apply the same principle.
My lord.
Then how you are getting the advantage? This is a flawed reasoning. If a wrong question is put, if the answer will be wrong, it is wrong for all. And generally it is followed that if the benefit is given to the one candidate, it should be given to all. Because all has suffered for this. So if you get 2 additional marks, the last person who has been selected also get 2 marks. How you can...
No, my lord.
Why not?
Question number 18.
No. All right. What
question number 18? 2 questions are right. My question is A, B, C, D. I have answered B question. My question is wrong. But last serial number questions maybe answer D question, which is awarded my mark.
I don't know.
No.
You also don't know,
my lord.
So how do you say that he will be deprived of this mark?
That's why these honest singles are directed to reconsider the unreserved category. Cut-off mark honest singles are directed if it is found that petition will the coming of cut-off mark. Directed to
reconsider single just direction only to consider your case. What about that fellow's case?
My lord.
Single judge is directed to consider your case and to give the marks if it is found you have given a wrong answer. Even you are giving the wrong answer will not be considered, you will be given the mark there. So you will give the additional marks, you come beyond this now, what 119 point and odd marks you will get.
Mr. Das,
my lord.
Just kindly reflect on what fell from my lord.
My lord.
You just reflect on that.
My lord. Para number 7.
Para 6 and 7, read together.
My lord.
If this is a kind of a moderation the court has suggested.
My lord.
Have you ever thought about it? What is the result of a moderation after the examination? Moderation applies to each and every candidate.
My lord.
You cannot be singled out. Mr. Tripathi and Mr. Muduli cannot be
no, my lord.
So everyone will be getting that mark.
That submission made,
that will not make any difference as far as the difference is concerned.
That submission made by the Honest Singular OPSC Council before the Honest Singular Judge. Para 7, the Honest Singular repeated that submission, my lord.
So, sir, you are not getting it.
So, and reaching it wrong, this inference. How can the London Single Judge says that that person will not get the benefit of that this wrong answers, wrong questions?
On such recommendation, federal petition within the cutting of marks so fixed that the London Single Judge directed to make a total gradation list in relation to unreserved category. Null candidate.
Read it. Quite that line you are getting.
On such recommendation, if it is found that petition which coming within the cut-off marks so fixed in all reserved male category. That's why
how we are reading. He says that all candidates, the answer scripts will be reviewed. Why from are getting that? There is a simple question we have asked you.
My lord.
London Single Judge is also asked to just see question marks and recategorize you, and if you have been given the wrong marks, the wrong marks will be added to you, and then you will get more than 120 marks. That not done.
My lord,
sorry.
I will verify. The opinion has not been solved. I will verify the.
No, we are reading from the judgment.
No,
don't have a copy of the judgment.
My lord.
We are not relating to referring to any other things.
On such recommendation, it is found that petition within the community or within the cut-off mark so fixed in unreserved category. So your unreserved category is not fixed. After evaluation, the 2 mark, the unreserved.
I think you understood that is an answer.
My lord.
By adding these 2 marks,
my lord,
to all the candidates of unreserved category,
my lord,
how the difference will increase or decrease?
The wrong committed by the OPSC, my lord.
Sir, wrong comment. Sir, did you ask you whether the UPSC has not committed a wrong?
My lord.
The question is very simple.
My lord,
Just
my
please reflect on this.
My lord.
By adding 2 marks to all the candidates in unreserved category,
My lord.
how the differential will be increasing. It's mathematics.
My lord.
Or the APPs are not supposed to know mathematics.
No.
The logic.
Yes,
The logic
see the section, this paragraph 7.
Similar.
The counsel for this OPSC, the Orissa Public Service Commission,
On that.
and there is no answer in the judgment. He says that whatever 1 mark is in favor of the petitioner in respect of the question number such and such.
My lord.
He has argued that if you want to give 1 mark each is wrong, apply to all.
My lord.
You agree to that?
My lord, my lord.
Oh, very good. You are doing it. You are happy?
Oh, my lord.
I think it will apply to all.
All, my lord. But my lord.
Nothing will change.
My lord.
Huh?
My lord.
All right. Heard Mr. Trilochan Das, the writ petitioner, heard Mr. Bhimu Prasad Tripathi, Learned Counsel, appearing for the appellant, Orissa Public Service Commission, and also heard the writ petition, Mr. Trilochan Das, in person. By means of this intercourt appeal, appellant has challenged the order dated 9/5/2023, passed by the learned single judge in WPC OAC number 3758 of 2017, Annexure 5 to the writ petition. Stop. Mr. Tripathi, Learned Counsel, has raised a jurisprudential objection in respect to the mentality of the writ petition. As the last person who has been selected for the post of Assistant Public Prosecutor has not been served notice. Moreover, and each vacancy has to be adjusted. The person who will be affected has an indivisible right to get to represent before the court. Be that as it may, what we find that the judgment is flawed. In para 7 of the judgment, Annexure 5 to this memorandum of appeal, the learned single judge has observed as follows. Para 7, Mr. A. Behra, learned counsel appearing for the commissioner, on the other hand, contended that if question number 58 has been wrongly drafted, then all the candidates who took the examination will be entitled to get 1 grace mark, and accordingly the cutoff mark will be higher in all category, including the UR male category. Despite the contention raised, the learned single judge, while disposing the writ petition, has observed as follows. Para 8 and 8. It is Mr. Tripathi, Learned Counsel, subject to his objection as to maintainability of the writ petition, has stated that in the phase of the objection raised by the OPSC, is found place in para 7. The inferences drawn under para 8 is unsustainable. Mr. Trilochan Das, however, has submitted that he has no objection if all the candidates appearing in the examination are granted 1 mark One more each against the questions number 18 and 58. Stop. In view of these submission made by the writ petitioner, without making any comment on the objection raised by Mr. Tripathi on maintainability, we direct the Orissa Public Service Commission to do the exercise by adding one additional mark against those questions.
Candidate 2016 to 2023 who has actually got the correct answers, got the marks for the correct answer. Now, if 2 marks each will be added to them, then there will be problem, my lord. There might be candidates who might have attended that question and might have got marks. In that view of the matter, if your lordship gives 1 mark each, then
what is the wrong in that direction?
Well, I'll leave it to you. I'm sorry.
There is no wrong because it was your duty. This person has come to the court.
My lord, I'll leave it to you.
All right. It's stop. We believe that no topsy-turvy will be created because of this exercise. Stop. However, who is appearing? Mr. Muduli, you are appearing in this matter.
Yes, yes. The government.
If any topsy-turvy is done, then we grant liberty to the state government in the related to the was the state home secretary was the member the
home secretary
secretary home department to adjust those persons who will be, if for any reason found that going out of the merit list for this direction, they can be adjusted against the available vacancy. In terms of the above, this writ appeal stands disposed of. The said exercise shall be taken within 30 days from today.
My lord, oblige.
There is no vacancy.
There is vacancy. He is making a categorical statement. There is vacancy.
Probably another recruitment has been done.
2016-17 vacancies, my lord. This advertisement was of 2016-17.
Covering those vacancies, I don't believe so.
7 years already have passed.
So last year there was a recruitment that was also challenged in several petitions.
No, whether they are still continuing, that issue you have not raised before the learned single judge.
Those persons are continuing. Those who qualified, they're all continuing.
No, whether they have appeared in the next examination and qualified, and for that reason they are continuing, or they are continuing on the basis of the earlier
2016-17.
So that is valid. Now.
That is valid.
That is not this overshadowed or eclipsed.
Yes.
Vacancy may not be available. Vacancy may not be available.
Because he cannot suffer for your wrong.
Man.
All right.
Yes, future vacancies can be done.
That is what the adjustment can be done.
So he cannot claim from that category.
No. Future vacancy. All right, I am making it clear.
Yes.
If the petitioner is found within the select panel after this exercise, he will be only entitled against the present vacancy because he have not worked unnecessarily. This all right.
That part,
no, that part should be there. However,
no, I have.
No, that part cannot be because you have not made them party. Otherwise, I was just on that ground.
Mention party last election persons.
You have not served the notice.
As per the my writ petitions,
I'm asking you, you have not served notice from that person.
The OPSC has not mentioned the address of the last selection
It is not
portal.
the duty of the OPS.
How the petition will be collected?
Go to the home department and collect from there. You don't give your responsibility to other person in filing the suit. If you file a suit against the defendant, can you say the state should provide me the name of the defendant and address? It is your duty to search out.
43 vacancy was arise due to
We have given the direction for making the adjustment.
Item number 6.
And in this case, in the last occasion, my lord has directed the Bhubaneswar Municipal Corporation to form a committee who's to inspect the site and
Today I'm filing an affidavit. And also
6.
serving a copy, my lords. The petitioner and state. Because here, as per Lordship's direction, my lords, a committee, technical committee has already been constituted, and that is Annexure B by 7, page 5. They visited the site and they have ascertained certain facts that have mentioned in para 6 and 7, that is relevant, my lords. As per the field visit, my lords, the main the waste canal embankment, there is a proposal of the government, that is a para 6, that they will be widening the canal embankment. That will be done by the R&B department. And the main drainage that will be flowing across the embankment, that will be also done by the R&B division of the government. That has already been entrusted by the government to the respective agencies. And so far as BMC is concerned, my lords, BMC will be constructing the internal drains, my lords, from the Bodagada colony to the, which will be connected accordingly to the main that drainage system. So unless that main drainage line is constructed, BMC is unable to construct the internal drains. And to sort out the problem of the waterlogged logging areas, that they are taking steps, my lords, promptly by installing the pumping motors and pumping motors, my lords. They are draining out the excess water for the time being. But for full-time settlement, full-time resolvement of the issues, my lords, it will take some time. As there is a proposal by the government itself that the entire waste canal
filed an affidavit, made some beautiful proposals, but there is no time limit when you will be going to implement.
My lord, they are actually only not BMC's concerns.
Affidavit has been filed by some politician.
No, my lord, because BMC is itself is not, my lord, government coordination is also required. R&B division, they have not constructed the entire widening of that, has to be done by the government, my lords. That is
Mr. Mohanty, that is a interdepartmental coordination is very much required, because you are
BMC must seek the assistance of the PWD department, what he is saying now.
R&B department to construct that.
You send letter to them and hold meetings to resolve this dispute.
Now, my lords, only through pumping motors they are draining out, but for full
that is also you are saying that is taking prompt measure towards installation of the pumping motors.
No, but they are installing, my lord. They are installing various areas. They are draining out.
There is no statistics where you have installed, where you have not installed, where you are going to install.
Instruction is that they are pumping out.
But in the affidavit there is nothing,
will also not object to that. Only, my lords, for permanent solution, my lords, it will take some time.
All right, for the time being, you also make a proposal to the state government.
My lord, that will be made, my lords. DMC will, my lords, issue, my lords, request the government also to expedite the, my lord, construction of the.
Okay.
Here in this case, this copy of the affidavit that has been served today just now, that enclosing the annex B/7, in that officer, as it appears, that constituted comprising the following in the inspector on site and submit a detailed report for resolving the issues. So report is not there, my lord.
Detailed report is awaited. We have stated in the affidavit.
So my lord, the Chief Justice expressed concern that this committee will submit a report and that may be a permanent solution, but what is happening now, what is the timeline? That you should have submitted. Where is the timeline?
Committee has not submitted any report.
A detailed report is awaited, my lord.
It is only on
The facts follows they have ascertained.
only on 13th September this committee was constituted. 3 days back.
So grant them some more time. At
Yes,
least
that is
6
right.
weeks time you provide, then you'll see. But Mr. D. Mohantil and counsel appearing for the petitioner, who has stated that water logging still is a serious problem. For the inhabitants of Burger, Canal Colony, and nearby places. During the rainy season, invariably the low-lying areas get submerged, causing huge damage and difficulty for the human lives in that area. So, on first, no, by the order dated 1/9/2023, sorry, not 1/9, by the order dated 11/8/2023, we directed Bhubaneswar Municipal Corporation to send a team consisting of the technical persons who have competence to make assessment whether the construction of the sewerage system or the drainage is adequate to manage the drainage of the rain, draining out of the rainwater during the rainy season, and whether the sewerage system that has been commissioned is properly functioning. The municipal corporation has filed their affidavit today apprising the court by the office order dated 13/9/2023. They have constituted a technical committee for resolving the issues of the said locality as per direction of the court. So, the said 5-member committee was constituted on 13/9/2023, and Mr. Pranay Mohantil and the council appearing for the municipal corporation has submitted that the said committee shall file the report after surveying the affected areas, and thereafter further action will be taken. It has been also stated in this affidavit that the government of Orissa has adopted a proposal for widening the Doya West Canal embankment and also for construction of the main drain line alongside the said embankment to be constructed by the road and building within bracket the Public Works Department. Stop. It has been further stated by Mr. Mohanty, Learned Counsel, that to give immediate relief to the affected person during the rainy season, Bhubaneswar Municipal Corporation has installed pumping motors at the waterlogged areas, and there is plan to install more pumping motors as a temporary measure to give some relief to the Burger Colony and other adjoining places. He has categorically stated, unless the project that has been taken by the government of Orissa for construction of widening of the embankment, canal embankment, and construction of the drain along with it is completed within a short while, the problem of waterlogging and consequential miseries of the citizens cannot be totally addressed. Stop. Let the matter be listed on 19th of October 2023. Six weeks. It goes down to November 4th. 7th November.
7th November.
7th November.
In the meanwhile, the Bhubaneswar Municipal Corporation shall obtain the report for the technical committee and decide what action they will be taken. A further affidavit will be filed before the next date. We also direct the Secretary to the Public Works Department, the Secretary to the Urban Development Department, and the Commissioner, Bhubaneswar Municipal Corporation, to hold a meeting amongst themselves in order to implement the proposed widening of the canal embankment and construction of drain along with that, in order to provide a permanent solution to the waterlogging, low-line flooding during the rainy season. Stop. We hope that both Bhubaneswar Municipal Corporation, Public Works Department, and the Urban Development Department will work in coordination to redress the problem that is faced by the Burger Colony and adjoining places. Stop. A copy of this order be served to Mr. D.K. Mohanty, Learned Counsel, appearing for the
opposite partner 124.
Opposite party number
124.
124. And to Mr. Pranoy Mohanty, Learned Counsel, appearing for the opposite party number
7.
7. Stop. Similarly, a copy be given to Mr. D.K. Mohanty, Learned Counsel, appearing for the petitioner. Both is D.K.
Yes. D. Mohanty. Is D. Mohanty. He is Mohanty. I am D.K. And your lordship may note that Mr. S.N. Das is appearing for opposite partner number 5 and 6. Kindly.
Where is he?
He is on his instruction. I am submitting. He is for Swaraj Board. Mr.
All right. It has been reported to us. Mr. S.N. Das, Learned Counsel, has appeared for the opposite party number 6.
5 and 6.
I am also appearing for the opposite party number 9 minutes for Watco.
All right. Mr. Zibriel and Counsel has appeared for the Watco.
Yes, ma'am.
Has appeared. Watco is the opposite party number
9.
9.
Has appeared for the opposite party number 9. Watco.
Yes.
Item number 8. Yes, ma'am.
My lord, I am having two term deposit, annexer 1, page 25 and 30. So when I approached postal department to withdraw that amount, they refused me. So I filed a writ petition, page number 44, my lord. Honorable single bench on 9/9/2021 directed to dispose of my representation within 2 months. That is page number 45, my lord. As page number.
You want to withdraw the money from the post office?
My lord.
And what representation he have filed the postal
Because
department?
my husband, petitioner's husband, is working as a postal employee. He is undergoing disciplinary procedure.
All right.
There is a blame of embezzlement of rupees 2 lakhs. So petitioner is the wife of the.
What is the wife of the petitioner?
She is a housewife.
What is the source of her income?
She got the money when her father met with an accident, motor vehicle accident claim and other deposits. So, my lord, they have rejected my claim, page 47, on the para 3, on the plea that in this regard it is pertinent to mention here that to adjust the loss amount sustained by the department, there is provision to confiscate the movable and immovable properties standing in the name of the offender and the dependents of the offender in accordance with PAD Act 1850. My lord, PAD Act, page 49, para 3, section 3, it defines public accountant as for the purpose of section 1 and 2 of this act. The expression public accountant means any person who has official assignee or trustee or servantcar is entrusted with the receipt, custody or control of any monies or securities for money or the management of any lands belonging, means particularly employees, my lord, or his sureties. And if there is an embezzlement, then section 4 says that the person or persons at the head of the office to which any public accountant belongs may proceed against any such public accountant and his sureties for any loss or defalcation in his accounts as if the amount thereof were an area of land revenue due to government. So this were I have challenged before in the WPC number 36852. And Honorable single judge rejected my prayer, my lord. Page 57, operative parties last one. In 70, in light of the aforesaid discussion and having regard to the present position of law, this court is of the view that the writ petitioner cannot be granted any relief by way of writ and the present writ petition is liable to be dismissed. My lord, what I was pleaded before the Honorable single judge, that money is a property without due process of law under Article 300A. That is page 61, para 9. On the same vein, the apex court in the case of state of Jharkhand.
Anyone is appearing for the central government?
My lord, pardon.
Please. Okay, you are appearing for the central government or the?
Central government.
All right. You are admitting the appeal.
No, my lord. Actually, in this case, the investigation under process, my lord, the present petitioner husband.
You are admitting the appeal. How does it relate to the investigation?
In
You are Mr. Jenna.
N.K. Sahu, my lord.
Okay, Mr. N.K. Saul and counsel appearing.
May I submit something, my lord? In this process, my lord,
we are just admitting your appeal today.
My lord, the matter is already have deposited 70,000 to the department. There is nothing outstanding to do anything. Already, this is a correspondence between the department and the concerned.
Proceeding has been stayed by the tribunal due to the stay order, the departmental proceeding has held up, madam.
My lord,
No, no, what Mr.
Sahu hear what he said.
The person has deposited the inculcated money.
You respond to that.
The accused, the delinquent officer has deposited the entire alleged, the defalcated money. What is the question of further recovery? Do you have the instruction? Because you are supposed to file an affidavit.
I file an affidavit regarding the pendency of the case before tribunal, madam.
Whether the money has been deposited.
No.
You have no
I
idea?
may take instruction, madam.
All right. Let the matter be listed again on 26th of September 2023. Meanwhile, Ms. Bobita Sahu, Learned Central Government Council, appearing for the respondent number 1, shall take instruction on the claim that the delinquent postal employee has deposited the entire alleged defalcated amount
Page 3, it is settled at 70,120.
What is that? There is nothing of that sort.
Page 3, dated 8/8/2023. This is to intimate that there is an outstanding loss of 70,120 rupees as on that the government account in the above mentioned case. As such, credit the said amount at the earliest at GL code number and intimate the office a credit particular of the same. My lord, I have deposited on 8/8/2023 last page, and I have been reinstated on 24th July 2023, my lord.
What is the last one? No. Let's go out still. It appears that the alleged defalcated amount the extent of rupees 70,120 see the communication of the Superintendent of Post Offices, Moyalganj Division, Baripada, dated 8/8/2023, has been refunded and deposited by the delinquent officer, the husband of the appellant, is the last name? Which last name? Stop. We asked the respondent number 1 to file a short affidavit whether the said amount has been deposited by the appellant or not. it is evident that the appellant order of suspension has been revoked with immediate effect by the order dated 20th July 2021-23. So the communications, this you file with a memo.
Yes, sir.
Next.
Item number 9.
No, well, item number 9, I'm appealing for the intervenor petitioner, flag B, IE. I'm led by Ms. Tamira. She's on her legs, Your Lordship. A short accommodation may be given, Your Lordship.
Your Lordship would kindly see, there are two matters. The first matter is a PIL, second matter is a writ petition filed by one of the private person. The second matter, if it is taken up fast, it will make the other PIL automatically insignificant, because in the PIL, the prayer is to pass some orders which has been stated in the second matter. So if Your Lordship kindly see the second matter, that's a prayer during pendency of a 41 proceeding, let there be no construction of over Achyutananda Matha. That is what the prayer is. Now there are two things, my lord. One is 41 proceeding in the meantime has been disposed of. I have shown the judgment last date to my lords. One second. So that petition has become infructuous. Because 41 proceeding is going pending. Secondly, I am for the petition. Secondly, if Your Lordship would kindly see what is the prayer in the petition. Not to have any construction over that Gadi. But that identical prayer was made in an earlier petition 8121 of 2020, and that matter has been disposed of, granting them liberty to approve the appropriate civil court. On the face of that very same order we have obtained from this Supreme Court, again the same prayer in another petition suppressing that fact. That fact has been suppressed. Kindly see, Lord. It is not correct, man. Kindly see. But kindly see that.
Time.
My lord, after that 41 order of the government court, they will file an appeal before the.
They have. So we have already filed the appeal already filed.
All these writ petitions has become infructuous.
No. State huge funds are not being utilized, my lord. Going back 20 crores of funds.
It has been declared as a public.
Decided whether it is public or private. Why the government says want to spare? How so later you are disputing that it is not declared as a public duty. No, you have to declare, my lord. He has already 50 crores of rupees will go back, my lord. WTC 431, but that is not plan, my lord. Kindly see the complete order. This is the cost item. The same person. Now, when kindly see why you see, my lord? No, shouting will not the best. I'm asking you a question of law. Yes, question of law. That order was passed. When the attempt was made, Mr. Lenta, to start with, you are not answering. Yes, my lord. If a submission is made, same person, you have to say yes or no. Yes, the same state that when you make your submission, consider what it is. The occasion of this writ petition arises when another attempt was made for construction. That is why the writ petition was made. And your lordship, while
the other all the same nature of cause of action arises.
Yes, my lord.
So we will not reopen that issue because the principle of
raised to the also. See, kindly see a certificate has nothing to do with the present definitions for that. Tendency of definition here, what is this? But till the decision is taken in the 31 proceeding, it has to be the construction. Calling on the parties to show things to high, opposite parties 3 to 7 shall not be directed not to make fresh construction around the properties of children in the town situated in the state cutter. Alternatively, one additional state council shall not be directed disposal application filed with the petitioner. Yes, I see one. The first prayer, same prayer in the under restriction. He has suppressed this restriction in this matter. Once it is suppressed, can you see one? The certificate, but here lost you have admission in the case. That is in the case that we are going, not to make any construction, but we are making the fence. Can you see this? That's the order. Where are the disclosed that restriction? Can you see, Mano? Where are the disclosed this restriction, Mano? In the second matter of the same prayer, can you see the certificate? They have suppressed the certificate, got the from the council. Maybe there is an same council. Yes.
My lord, my limited prayer is now 41 is a statutory proceeding. 41 it has been declared as a public deed. And they are challenging it before the next phase, that is the commission. They have already said, they say that they have already challenged. So that will determine the entire the case.
Yes, that is.
One predicament is a huge gathering is taking
cycles. Challenge the order by filing an appeal. Yes. So what prevents you? I mean, what is the benefit of keeping this pending? Yes. I am appearing in the Endowment Commission what the sanctioned by the so he needs us. Fast appeal, my lord. Because time that I'm asking you, yes, so what is the purpose of keeping this matter pending here? I'm stalling that appeal here. Yes. So the question of how benefiting, please answer that. The purpose of the other side is to see that these and decide that here. No, that is action. You see, the appellate authority, as per the Hindu Religious Endowments Act, you take a decision. Where you may get a stay order, you may get
everything they can give.
Whatever order we are seeking here, to dispose of that petition pending before the Assistant Endowment Commission. Surveying. Which are short proceeding said before the commissioner this matter is pending before the court. No, my lord. No question of saying that they are clarify. We'll clarify that the appellate authority shall proceed in accordance with law and pendency of this petition will have
25th we keep it and then we'll
yes, so we are to 21st keep it.
Mr. P.K. Roth, Member Senior Counsel, extended by Ms. S. Das. Yes, sir. Client Counsel appearing for the opposite party.
Open number 2. And also PL also appearing. In the last order, the Lordship has
produced the order dated 5th April 2017, delivered in WPC number 8121 of 2015. In respect of the dispute relating to the same land, Right. Stop. Which has been styled as the properties of the deity. Achyutanand Dev Gadi, no, that's Gadi at Nemalo. Stop. Right. Well, disposing of the said writ petition, being WTC number 8121 of 2015, a division bench of this court has observed as follows, quote, considering the submission made and keeping in view the fact that the writ petition involves disputed question of fact, we are not inclined to entertain the writ petition in exercise of the extraordinary writ jurisdiction. Stops up there. It is open for the petitioner to avail such remedy as provided in law, unquote. On the same dispute, according to Mr. Roth, this present writ petition has been filed, and also by suppressing this order dated 5/4/2017. Stop. That apart, Mr. J.P. Patnaik, Warrant Counsel, has stated that
Under section 41 of OHRC Act.
Which area? This is a letter.
The last number is different.
41 judgment around stated that OA number 14 of 2012 under section 14 of Orissa Hindu Religious Endowment Act 1951
41 units.
as was pending as was pending before the additional Assistant Commissioner of Endowments Kotak has been disposed of by declaring the deity as the public deity.
That is at page 48 of that order.
So,
That order
is not there.
48 is the
State of counter.
order of the 41. 41.
So that order is on record. I will get it. 41 order.
We have given copies, man.
I have given last date. I had given a copy. Oh,
Flat 10.
flat 10.
Flat 10 of the PI.
14510. Correct.
Page 48. At page 48,
Not for declaration. This is the High Court order. Another High Court order is there.
This is the order. My lord, I have given. They have already given that copy.
The said order is also available in the record.
That's right. We had given it last week.
In WPC number 19394 of 2023, the prayer that has been made is also close to the dispute as raised in this writ petition. But the prayer is prayer is entirely different. The prayer is related to development of the said Peter, providing amenities and accommodation for the sages and devotees, and also scholars and visitors. The direction has been sought in that petition to prepare a detailed project report, DPI, for undertaking the project, the said project for development. So, therefore, if the issue is decided in this writ petition, the substantive part of the relief in the first writ petition will be covered. Where the matter will be listed on 25, it is there. In that first writ petition also, in view of the order passed today, this is in such. And just for the second writ petition below that, you write, it is made absolutely clear. If there is any prayer for adjournment is made by the petitioner, the interim order is passed by this court shall stand vacated without further consideration.
The interim order may continue.
That's right. The order shall continue, but it is made clear if you even 6 for adjournment, that interim order will be vacated. We have given enough reason already.
Right. 20 people. Grateful.
Obliged. Yes, then. This is disposed of.